phones or other devices in the jury room, which will be locked while court is in session. If your watch has text or communication features, please disable these features while in the courtroom. You may use your phone or device for your own personal needs during breaks outside the courtroom. However, you may not use them at any time to obtain or divulge any information about this case. You also must turn your phone or device off and not use it at all during deliberations. If there are any media reports about this case, you are not permitted to read, watch, or listen to those reports. You must also avoid any social media conversations or content about this case. You, as jurors, must base your decisions solely on the evidence you hear in the courtroom. During the trial, I will decide which rules of law apply to the case. You will receive a full copy of the legal instructions applicable to this case at the end of the trial. It will be your job to decide what the facts of the case are based upon the evidence presented. Once you determine what the facts are, you must then apply the law and my instructions to the facts. From that application, you will arrive at a verdict. Your deliberations in this case will be secret. You will not be required to explain your verdict to anyone. If, after your deliberations, you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. Therefore, you should not concern yourself with considerations of sentencing or punishment as you determine the facts of this case. At this time, I recognize the State of Tennessee for the reading of the indictment.
Case number 116806, State of Tennessee versus Geoffrey Ian Paschel. Count 1. The grand jurors for the State of Tennessee, upon their oaths, present that Geoffrey Ian Paschel, heretofore to wit, on or about the 9th day of June 2019, in the state and county aforesaid, did unlawfully and knowingly confine Kristen Wilson so as to interfere substantially with the liberty of said Kristen Wilson, where said Kristen Wilson did suffer bodily injury in violation of TCA 39-13-304 and against the peace and dignity of the State of Tennessee. Count 2. And the grand jurors aforesaid, upon their oaths aforesaid, do further present that Geoffrey Ian Paschel, heretofore to wit, on or about the 9th day of June 2019, in the state and county aforesaid, did unlawfully and knowingly cause bodily injury to a domestic abuse victim as defined by TCA 39-13-111, to wit, Kristen Wilson, in violation of TCA 39-13-111 and against the peace and dignity of the State of Tennessee. Count 3. And the grand jurors aforesaid, upon their oaths aforesaid, do further present that Geoffrey Ian Paschel, heretofore to wit, on or about the 9th day of June 2019, in the state and county aforesaid, did knowingly prevent Kristen Wilson from requesting assistance in an emergency from a law enforcement agency in violation of TCA 65-21-117 and against the peace and dignity of the State of Tennessee.
The defendant pleads not guilty to each and every count of the indictment.
Thank you, counsel. The jury has been sworn. The indictment's been read. The defendant's pled not guilty. The State is recognized at this time for its opening statement. General.
June the 8th of 2019 is a Saturday. And what you're going to learn throughout this trial that I think probably might go to tomorrow, over the next day or two, is that at that time, Kristen Wilson was engaged to the defendant. And that Saturday started out perfect. The two of them went to dinner. They stayed there for about 3 hours. Kristen's friend was the server there. They had a nice meal. They had some drinks. They talked with friends. They then went back to Kristen's house to let her dog out, regroup for a minute. And then they actually had plans to go out and meet some more friends. You're going to hear from Miss Wilson. She's going to tell you that when they got back to her house that night, she took the dog for a walk. Mr. Paschel stayed inside the home. She's going to tell you that right before she walked back in the house, she stopped in front of her neighbor's house. She texted her friend. She says, "Hey, we're about to leave. We'll be there in a minute." She never made it. She never made it to meet her friends after that. Because what you're going to learn is when she walked back in that house, she was attacked by this defendant. You're going to hear from her how he grabbed her by the back of her head and slammed her head into the hardwood floor repeatedly. You're going to hear how he grabbed her by the back of her neck, drug her around the house, drug her up the stairs, You're going to see where she had blood on her face and was trying to reach for a light switch. You're going to see blood smears on the light switches. You're going to see blood splatter on the wall, dripped on the floor. You're going to hear how she tried to get away and she couldn't. You're going to see scrapes on her knees, scrapes on her elbows, bruises everywhere. Bruises on the back of her neck where he grabbed her when he was slamming her head on the floor. You're going to hear how this happened for what seemed like forever. Ms. Wilson's going to tell you that she blacked out multiple times, lost consciousness because of the injury to her head. And then she's going to tell you that the defendant told her, go wash your face. After he took her phone and took her car keys, go wash your face. So she did. She was terrified. She just wanted it to stop. She went and she washed her face, she washed all the blood off of it best she could. He said, go lay down. So she did. She went in her room. She laid down. He sat on the edge of the bed for about an hour to 2 hours while she laid there in fear of her life, with nowhere to go, no way to leave. She's going to tell you that he had her phone, he was going through her phone, deleting things. He synced up her phone to his account, his iCloud account, virtually deleted every trace of himself on her phone, disabled the screen. And she's going to tell you that then he tried to lay down. And after laying there for 2 hours, after being brutally beaten, she decided to take a chance and run. And she did. She ran out of her house at 2 o'clock in the morning, barefoot, no phone, no keys, nothing. She ran over to her neighbor's house, Miss Gouge, I talked about in Bordeaux. She begged her to let her in. Miss Gouge calls 911. You're going to hear that Miss Wilson was so scared when she got to Miss Gouge's house, she hid behind cabinets. She was so scared that he was going to come after her, she didn't even open the door for the police initially because she thought it was him. You're going to see the injuries sustained by Miss Wilson. And I can't exaggerate this. You're going to see a knot on her head, the size of a fist, basically, from repeatedly having her head slammed into the floor, slammed into the walls by this defendant. You're going to hear how terrified she was that night. Being trapped in her own house, with no way to call for help, nobody there but the person who had just attacked her. And I'm going to come back up here after you hear all that evidence. And I'm going to ask you to find this defendant guilty as charged of aggravated kidnapping, domestic assault, and interfering with an emergency call. Because that's exactly what happened on June the 9th of 2019. Thank you all.
Thank you, Judge. Mr. Isaac?
An opening statement's like a roadmap. In June of 2019, the road takes us to North Shore Drive, State Highway in West Knoxville. On that evening, Geoffrey Paschel and Kristen Wilson were having a night like a night they'd had for the last 2 years. They were engaged, they've been dating since 2017. You'll hear they did things like most young people do. Hiking, go to Florida. Geoffrey would go to school events because Miss Wilson was a 4th grade teacher at Sequoia Elementary. But you're going to hear, unfortunately, like a lot of people do, they went out to dinner, and the proof is going to be very candid, very straightforward. They had a number of cocktails with dinner. The state mentioned in their opening statement that the server was a friend of Miss Wilson's. Well, that could be good, and that could be bad. The friend, as you're going to hear, had a propensity or a habit of pouring drinks that were strong and drinks that were free. The young couple had an enjoyable dinner at the Brasserie Restaurant, a trendy restaurant down at the end of North Shore next to Pellissippi Parkway. And you're going to hear they went back to Miss Wilson's house like they'd done time after time after time again. But as the evening progressed, you're going to hear they went to walk the dog, went to meet some more friends, going to another bar. This is mutual. This is voluntary. Notwithstanding the fact it was 11 o'clock, the plan was, let's go out and let's continue. At some point, you're going to hear that the couple argued like most people do on occasions like this on 11 o'clock in Knox County, Tennessee, after a number of cocktails. And there was the specter of jealousy. And you're going to hear the story spin two different ways. One was Miss Wilson jealous of Mr. Paschel. Conversely, was Mr. Paschel jealous of Miss Wilson. Unfortunately, as we hear all too often, one party saw the other party looking at a phone, jumped to conclusions, and then here's where the road splits and diverges. You're going to hear that based on the factors, alcohol, whatever, that Miss Wilson became upset. You're going to hear that there was an argument. She injured herself leaving the house. She injured herself during the argument and the interaction with Mr. Paschel. No more, no less. You're going to see pictures. And when you see those pictures, I'm going to ask you, when I get back up here after the proof of this trial, to call upon your life experiences and your common sense. And the proof is going to show that Miss Wilson had a pump knot, significant, some inner bleeding in her mouth. And you're going to hear that happened because of injuries she incurred leaving the house down the road that Mr. Paschel is going to take us on during the course of this trial. But the state is going to tell you that Mr. Paschel brutalized her for no reason whatsoever. And it went on forever. That after walking the dog, that Mr. Paschel grabbed her by the head of the hair, began violently banging her head on the hardwood, banged it all the way up the stairs, banged it in the living room, banged it back down. Physically improbable, physically impossible. So when you look at the evidence and you hear the divergent stories, look at your common sense, because the state's theory, for it to work, for them to say that this assault was more, if there was an assault, or this accident, after a number of strongly poured cocktails, it has to be more, because the neighbor wanted to call the police. So you've gone down the rabbit hole, is what you're going to hear. But if you hear, if the proof matches the story that the state is going to present to you, you would have seen injuries that were graphic, injuries that were horrific. You would have seen someone going to the emergency room being carried out in a stretcher because, according to the state's theory, it went on and on and on and on forever. But the truth of the matter is, Miss Wilson, were they arguing? You're going to hear yes. Were there mutual jealousy? Yes. Did she hit her head on the wall on the door frame leaving? Yes. The story's incomplete because you're going to hear it's kind of like Mark Twain, good liars give details, great liars don't. If you start telling a story and you're adding and you're diminishing, there's gaps of time that can't be explained. And the reason there's gaps of times that can't be explained because you couldn't have injured someone the way the state is going to tell you it happened. So one, we don't want to make this case a he said, She said victimize, not victimize. This is a case of whether Mr. Paschel committed a crime beyond a reasonable doubt. Look at the injuries, look at the photos. Scrutinize the photos and look at your common sense and ask if you have a pump line, you hit the wall or you hit the door, what would present itself? If your face had been pummeled time after time after time after time, whether you would have minor bleeding or whether you would be swollen beyond belief. Injuries, yes. Caused by Mr. Paschel? No. But there's one common denominator. You had two young people that were out late, they were drinking, they were jealous, and it's unfortunate that we're here. But the road from the North Shore, from the Wilson residence to the brasserie, to walk the dog, and back, does not lead itself to a person who had dated this woman, was engaged to this woman, has young children, and the state's going to want you to believe that like a maniacal serial killer picked her up by the hair of the head and just pummeled her for minutes, upstairs, downstairs. Physically impossible. And then look at the photos. Again, the pump night doesn't look good. And we're sorry for that, but we're not going to take responsibility for doing something that we didn't do. Because we can't. So, don't get lost in the emotion. The he said, she said. Get lost in the facts and looking at your common sense, because what you're going to hear is Mr. Paschel did not inflict the wounds in a way. And then ask yourself about the gaps, the time. If she's lucid with the police code, if she's lucid when she comes to her friends, then why are there gaps of time? Because you know why there's going to be gaps of time you're going to hear? Because you can't injure someone the way Miss Wilson said she was injured. It would be physically impossible to have inflicted the injuries the way they were by the hair of the head, upstairs, downstairs, under the wall, banging the floor, and not have been called out in an ambulance. Also, grabbed her by the back and there's bruises. Look at that. The bruises aren't right here. There are bruises that track down the spine, and the bruises where you're going to see or hear Miss Wilson fell. This trial and the proof and the journey that you're going to go on in this trial happens all too frequently. You have two people in a relationship that care, that get along, and then you have drink after drink after drink. You have the proverbial pick the phone up, who are you talking to, who are you not talking to, storming out this, that, the other. Unfortunate. Immature. But regardless of the drinks they consumed at the brasserie, regardless about who thought who was texting who, Mr. Paschel did not inflict the injuries that the state is going to seek to attribute to him on Miss Wilson. And at the end of this journey, down North Shore to the brasserie and back, after cocktail after cocktail after cocktail, we're going to ask you to return a verdict of not guilty. Thank you.
Thank you, Mr. Isaacs. Gentlemen, Judge Wilson.
State calls Lauren Gouge.
As she's coming into the courtroom, ladies and gentlemen, recall I didn't explain to you very well how the alternate juror process works. The way that'll happen at the end of the trial is that I have this box here with all of your names, and I'll pick one of your names randomly out of that box. That will be the alternate, so we don't know who it is as we go throughout the course of the trial. Mr. McMillan, I didn't want you thinking just because you were juror number 13 that you do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat.
I'm gonna have you pull that microphone up just because we're recording. Can you state your name for the record and spell your last name, please?
Lauren Gouge, Gouge.
We'll have you pull it. Let's see, you might need to, yeah, just because we gotta make sure we're getting everything. I'll have you say that one more time.
Lauren Gouge, Gouge.
Ms. Gouge, do you know Kristen Wilson, or I guess Kristen Chapman now?
Yes.
And how do you know her?
She's my neighbor 2 doors down.
Did you know her back in June of 2019?
I did.
And did something happen in the early morning hours of June the 9th of 2019 that's brought you into court today?
Yes, it did.
Can you tell the jury about that?
Yes, I had just fallen asleep. It was a Saturday night, and my doorbell rang, and which is not usual for me. And I live alone, so I at first didn't go straight to the door. I stayed in the stairwell and yelled out and asked who was at the door, and just yelled as loud as I could. And she yelled back, "It's Kristen, your neighbor. It's Kristen, your neighbor. Please open the door." And so I went to the front door and opened the door, and she said, "Can you please call 911?" And I invited her in and closed the door and locked it and called 911. She looked like she had been in some kind of accident, or she was kind of had a lump on her head, and so I called 911.
Okay. And what was her emotional state when she showed up at your house?
She was in shock, kind of, and scared, very scared. She was worried that, she wanted to go in the kitchen, in the corner of the kitchen, away from the windows. That was the first thing, kind of for protection, because she was scared.
Okay. And do you know about what time it was in the morning?
I don't know exactly what time it was. I would say it was probably after midnight, maybe between 11:30 and 1, if I had to estimate. I don't know exactly what time.
Okay. And Judge, at this time, the parties have agreed prior to stipulate to the 911 call.
Okay, very well.
This is just 1 and 2. And,
The call and the CAD report will be received as exhibits 1 and 2, is that fair? Any objection?
None.
Those be received.
and we have published the 911.
You may.
with a GMT. Call 1 on Sunday, June 9, 2019 at 1:46 a.m. with a GMT offset of negative 240 minutes. Agent ID extension is 204. County 911, where are your emergencies? I have a neighbor that's deceased. Okay, where I have a neighbor that's deceased. We are at 15. We're on 501 Aldenwood Lane. Okay, and where's the person who hit her? He is 2 doors down at 1425 Aldenwood Lane. Her dog is there, in the house, and she's concerned about her dog. She is severely beaten.
Does she need an
And came to
ambulance?
my house when she did not need an ambulance. I don't think. She has a head trauma.
Okay.
So,
Yeah, we're gonna.
very large knot. Okay. I'm very concerned.
Okay, we're gonna go.
Are you there?
I'm here. What's your name?
I'm Lauren Gouge, Gouge is my last name.
Okay, who hit her?
Her boyfriend.
What's his name?
Geoffrey Paschel, Paschal,
How old is he?
How old is he? 41.
Is he what, Hispanic?
White. Caucasian.
Okay. Is there any weapons in the house?
I have no weapons here. Is there any weapons in your home? She does not think so.
Has he been doing any drugs or drinking?
Has she been doing any drugs or drinking? She's been drinking.
She has a teeth.
No, he has been drinking. They both have been drinking. It was hours ago. He had her hours ago. She just got out, and she just came to my door, and she has a very large head wound.
Okay. So you're 1505 Aldenwood?
1501, Aldenwood Lane.
Okay, what's your name? I'm sorry.
Lauren Gouge, Gouge.
Can you verify your phone
My
number?
first name is Lauren. 865-599-6481.
Okay. What's he wearing?
What is he wearing? Do you know what he's wearing? She's not sure. He had jeans and a red t-shirt previously.
So red shirt and jeans?
Yes.
What kind of vehicle does he drive?
He drives, what does he drive? A white Nissan Versa.
What's the female's name?
Kristen? I'm here on the second. What else am I that?
How old is she?
Kristen Wilson, she is 28, 29.
Is she white, black, or Hispanic?
Caucasian,
What are you
white.
wearing?
She is wearing a navy blue romper. I don't know how to explain it. It's a one-piece outfit, navy blue,
Okay.
with flowers.
I'm going to transfer you back to the ambulance service, okay? Don't hang up.
Okay, I won't.
Amber Communications, what's the location of your emergency?
1501 Aldenwood Lane.
1501 Aldenwood Lane?
No.
Okay, so it's not 1425?
No, the victim is at 1501 Aldenwood Lane. The perpetrator is at 1425. The perpetrator is at 1501 Aldenwood Lane.
Okay.
And did you wait with Ms. Wilson in your home until the police arrived?
Yes, I did.
At some point, we just heard the 911 call that you made initially. Did you make an additional call at some point?
I did. The police arrived pretty shortly after that phone call. But like I said, we were in the corner of the kitchen away from the windows because we were scared that he might be following and come, you know, to my house and follow her. She showed up without shoes on, so she had run to my house to escape. And so she was worried that he might be following her. So we were in the corner of the kitchen, and the doorbell rang, or there was a knock at the front door. But I didn't want to answer the door without knowing who it was, and the police didn't have their their lights blaring or anything like that. And so I called 911 again and asked if they could make themselves known that it was the police, so I felt safe answering the door.
And was it actually the police?
Yes, it was.
Okay. And did you go with Ms. Wilson to the hospital?
I did.
Okay. Did you drive her there?
I did. I drove her
Okay.
there.
And Judge, I'll pass the witness at this time.
Cross-examination.
Good afternoon, Ms. Gouge.
Hi.
My name is Gregory Isaacs. I represent Geoffrey Paschel. You live adjacent to Ms. Wilson, correct?
Correct.
Very short,
It's, yeah, 2 houses down.
2 houses down. And you had never had an occasion where Ms. Wilson complained to you about any behavior as it related to her and Geoffrey before, correct?
That is correct.
And you, that evening, did not observe any action, conduct, activity related to Mr. Paschel, correct?
Well, I observed what she was telling me.
What she was telling you.
Correct.
And when the 911 operator asked if she'd been drinking, she told you correct. She had.
She told me that they had been out to dinner that night and had had some wine at dinner.
Well, I didn't hear that in the background of the call. Did she say she had been drinking, yes or no, when you asked her pursuant to the 911 call?
Can you ask the question?
Why do you have some hesitation with answering the question?
Judge, may we approach?
You may.
Yeah, that's what she said. I don't think she understood exactly what you were asking. I understand your question to be, did Ms. Wilson say that to her when the 911 operator asked? Is that correct?
Yes. Did she tell you?
And there you're looking at the defendant in this case, Geoffrey Paschel, formerly starred in TLC's show 90 Day Fiancé. Before the 90 days, he's 43 years old, facing some very serious charges, including kidnapping and assault.
911 operator's question, Ms. Wilson told you that she had been drinking that evening, correct?
Correct.
And when you talked to the 911 operator, you were honest and truthful, correct?
Yes, sir.
And you had basically no information to provide to 911 dispatch other than what you had been told by Ms. Wilson, correct?
That's correct.
And you indicated that you thought this occurred anywhere between 11 and 1, but the call indicated that it was received about 1:46.
Yeah, this occurred over 2 years ago, so I knew it was in the middle of the night, and I had been probably asleep for less than an hour, and I was just basing that based on when I normally go to sleep. So, like I said, it was an estimate. I didn't know an exact time.
Well, did Ms. Wilson tell you that this encounter took place hours ago?
She said yes, it had been going on for a little while.
Well, if she got home at 11 and she's telling you that the attack lasted 3.5 hours, if there was an attack?
If who got home at 11, I'm confused by your question.
Did she tell you that they had went upstairs and went to sleep? Did she tell you she'd fallen asleep?
No, she did not.
Okay. So you seem, it's been 2 years, your recollection is somewhat, you would agree, hazy about what you observed on that Saturday night, June 9th, 2019?
I would say the exact time, yes, but the details have stuck with me.
And you would agree with me that when she came to your house, she wasn't dressed as if she had just left the brasserie having dinner and cocktails, correct?
She was still dressed that way, yes.
She was?
Yes.
What was she wearing?
She was wearing a blue one-piece, I call it a romper. It's like a dressier outfit, but it's a one-piece that is kind of in style now. I don't really know how to explain it, but it's just a one-piece outfit that zips up in the back usually.
And when Miss Wilson was at your house, she never went into detail about the specifics of what she say happened, correct?
Can you ask the question again? I'm sorry.
Miss Wilson didn't go into detail about what she said happened while she was at your home.
She did go into detail, yeah. Certain details about how the big bump had gotten on her head and that kind of thing, yes.
Well, did she say it lasted, an altercation lasted 3.5 hours?
She said that they had been arguing and the abuse and fighting had started after they got home, and then that he had taken any means of her to be able to call 911 away from her. Mm-hmm. So he had taken her phone and her computer, and she had no way to contact 911, and that's why she was coming to my house for me to call 911.
Okay, and you're saying she was dressed as though she just left dinner at 1:43.
Yes. She was still dressed in what I would assume she went out to dinner in, or what would be appropriate to wear to a restaurant to dinner.
And she said they were arguing, so she acknowledged that they were drinking, and was there an accusation of infidelity?
No.
So she did acknowledge they went to dinner, they were drinking, correct?
Yes.
And you say they were drinking wine?
Yeah, that's how I recall it, yes.
And the argument, there was an argument that started at the Brasserie restaurant, correct?
From what I recall, the argument started when they got home from the Brasserie restaurant, but that's how I recall it.
So we knew they both were drinking, and we knew the argument was which takes, it was mutual regarding issues of infidelity and monogamy.
I don't recall exact details of how it started. I know that an argument ensued when they got home from the Brasserie, and that's all I have.
Well, at this point, when the police arrived, have you seen the videos, the body camera footage?
I have not.
Well, you called 911 on that Saturday evening on June 9th/10th on 2 occasions, correct?
Yes, sir.
And Miss Wilson, at that point, when the police arrived, she seemed composed. Would you agree?
I would not agree with that, no.
Well, was there anything preventing her from calling 911, or you handing the phone to her so she could tell dispatch what happened?
She was very distraught and very scared when she showed up at my house. So I think she was in too much shock to be able to do that herself.
Well, she could answer your questions, correct?
She could.
What did y'all do while you waited for the police? Drink coffee? What was
No, we hid in the corner of my kitchen,
hid in the corner of your kitchen?
away from windows.
And she indicated that she thought Mr. Paschel was coming over.
She was afraid that he had followed her over because she had escaped from her house.
Did she tell you that he was in bed asleep?
She did not. Well, can I correct that, please?
You may clarify your testimony.
Thank you. She told me that they both were in bed. He had fallen asleep. She had pretended to be asleep, and that's how she got away into my house.
Well, did she tell you that she had been drinking mimosas at the brasserie?
Judge, ask and answer at this point.
Let me withdraw that question. Did she tell you that they went upstairs and passed out?
No, she did not.
And you basically have no personal knowledge when they arrived at Krista Wilson's residence, correct?
Correct.
You have no personal knowledge about what happened at her residence aside from what she told you, correct?
I did not eyewitness it, no.
I have nothing further.
Ready to write? Ms. Gouge, thank you so much
Thank
for being here
you.
today, ma'am.
Appreciate
Free to
it.
go. Ladies and gentlemen, at this time, I've been told that your lunch has arrived. So we will take a break here. I also have some cases on my regular docket that I need to take up while you're back there eating. So you'll be going with the court officers. Again, it's important that you don't discuss this case with each other or with anybody else. Just have a very good and enjoyable lunch. All rise for the jury. You may leave your
What a case this is already shaping up to be. Defendant Geoffrey Paschel, who formerly starred on a reality show, is being accused of brutally beating his fiancée at the time. And you heard both sides detail different stories in this case, and then you heard testimony from the first witness, who a neighbor of this alleged victim, what's known as an outcry witness, someone that an alleged victim may go to after experiencing something. And the allegation is that he brutally beat her and then held her there, stopped her from being able to call for help, and she escaped from her own home worried about her pet. We're going to take a quick break and then dive more into these awful details when Court TV Live continues. And by the way, October is Domestic Violence Awareness Month. We'll be right back. Welcome back to Court TV Live. I'm Julie Grant. If you're just now joining us, we welcome you to Court TV Live. And we just saw the start of a very disturbing domestic violence case beginning in Knoxville, Tennessee. The accused is Geoffrey Paschel, 43 years old, starred for a time on TLC in the show 90 Day Fiancé. And he's being accused of brutally beating his fiancée at the time. This incident said to have occurred in 2019. He is adamantly denying these allegations. His defense attorney telling the jury in opening statements that the woman injured herself as she was leaving the home. Prosecutors said she had a knot on her forehead the size of a fist. And as we went to a break just a few minutes ago because the jury were sent out to eat their lunch, the attorneys stayed in the courtroom to make some arguments before the judge. So we want to listen in to all of that together now.
The portions where officers encounter the defendant in Ms. Wilson's home. However, I also told defense counsel that should the issue of them trying to say that Ms. Wilson was belligerent and intoxicated and this, that, and the other thing come up, that I would ask to play the portions of the video where she's actually speaking with the officers. I do believe that now that door has been opened, given not only Mr. Isaac's opening statement, but the questions propounded over and over to Ms. Gouge about what Ms. Wilson was drinking and everything like that. And so I think the jury at this point should be able to actually physically see.
Excuse me, can we ask Ms. Gouge to leave the room since I've asked for the rule? She's a witness and we're arguing she may be recalled.
She's subject to recall?
Well, in light of what she is saying, possibly.
She's not going to authenticate a body cam, is she?
Well, there are things on that body cam that's materially different than she testified.
All right, very well. Ms. Gouge, ma'am, if you would please wait outside the courtroom and don't come back in until you're called by one of the parties. Thank you, ma'am. Go ahead, Jim.
Judge, I would just ask to,
I'm
sorry.
Go ahead, ma'am. I'm going. There you go. Go ahead.
At this point, Judge, I would just ask to be allowed to now go in and actually show that portion of the body cam where the victim initially encounters the officers. That way the jury can then make a determination as to whether or not they believe that she was, falling down drunk, causing all these injuries to herself. I think at this point that's been raised by the defense, and I would ask to play that. Additionally, Judge, the portion of the body cam that the court asked us to redact earlier, the reason that it was asked to be redacted is because the defense said that the officer could not make that determination as to how the injuries occurred. Well, then Mr. Isaac stands up in opening statement and literally does the exact same thing, but just in the reverse, and says that there's no way that the injuries sustained by the victim could have occurred the way that she said it. I mean, that's exactly what the officer was saying at this point.
We'll start with the video of the officer and his statement. I didn't exclude that under 701. I specifically said I was not ruling under 701. I was excluding it because it's hearsay. It's clearly hearsay. It's an out-of-court statement offered for the truth of the matter asserted. It's recorded, it's played here, it's from an extrajudicial setting. That's hearsay and that's accepted. So the state cannot play that portion of the video. Again, I have not issued a ruling on his underlying opinion. Okay, that's still in play potentially. Now, as to the body cam, I mean, it's the state's case. The state can put on whatever relevant proof they think. I don't know what pretrial arrangements you all have made or what stipulations you've come to, but if the defense wants to object, I mean, is there an objection, Mr. Isaacs, as to the body cam video of the victim being shown?
We would object that it is the footage showing her demeanor, etc., is not relevant as to the allegations involving Mr. Paschel. I mean, the problem is it's replete with hearsay, and it's hard to extract the hearsay from that snippet. We had an agreement. And if anything opened the door, the state opened the door when 911 asking if she had been considered.
Well, yeah, that was an agreed exhibit, though. That came in
That was.
agreement, and it was chock full of hearsay.
It was not.
But that came in by agreement of the parties. There was a ton of hearsay in Ms. Gouge's testimony that was elicited by both sides. So are we really in a position now to be saying that we're not going to allow the hearsay spoken by the actual alleged victim to the police?
We would continue, Ms. Gouge is a separate issue, although it's intertwined with Ms. Wilson. We would object to body cam footage that showed Ms. Wilson and contains hearsay. Under hearsay because it's an out-of-court statement and an extrajudicial statement offered for the truth of the matter asserted, and also under 401 and 403.
Okay, well, I'll need to see it. Can you play it, Jenna? How long is it?
It's about 5 minutes more than what the video that I sent last night.
Do you have 10 minutes?
It's just a small portion of it, yeah.
Okay.
Sorry, we thought you were done.
Oh, okay.
We're very scared.
That's all right. The handle
Please come in.
is here. Is that all right? Okay.
We left the lights off because we're very scared.
All right.
My dog's Carlos.
All right, you're fine.
This is Kristen.
Hey.
We left the lights off and we stayed down
Yeah.
because we didn't know. I mean, she's been very bad. She just, I was asleep, she rang the doorbell.
What's going on?
She's gonna be very seriously. Yeah. We got him breakfast and he turned me up against my kitchen floor and my living room floor. He flipped my couch and turned me up against it. And probably about 2, maybe 3 hours ago, I've been laying in bed pretending to be asleep. He had my phone. He went through my phone. He was playing on it and deleting everything.
Okay. These guys are gonna check you out. Have them do that first or ask the questions, okay? Did you just walk out the house, run out of the house and do it?
Yeah,
Did you grab first and ready?
no, I never been to it.
You're fine. What's your first name?
Kristen. K-R-I-S.
Are you familiar with their situation? Has this happened before?
Our dogs are friends and play and
Oh, good.
My husband, who worked before, this is the first time that it's done to this degree. I never knew, but she didn't know where else to go, you know, and when I was scared, she rang that much stress, first of course I opened, so we just been much down, and when you guys knocked, we thought it was him, so that's why I called 911 again. I'm sorry.
No, that's all right. I understand. I saw you poke your head out, and when you didn't open the door, I figured that's what you
Well, I told my dad because we just got much down here because we weren't sure if he was gonna come after us or not, so I'm sorry. We didn't know what else to do. Yeah.
You run subdivision, what do you want that? In August?
Yeah.
Did that hurt?
Yeah, it does.
Yeah. You know, one.
But it's not, it's just like you got it. I'm sorry?
hours, so time we can get the work done up. You want me to tell you what I do, or you
Yeah, just, I'll go with you. I'll go with you.
either way, you see.
Did I not tell you that? I'm so sorry. Will you take me? Of course, thank you, of course.
How tall?
I'm sorry?
How tall?
5'7".
What's your,
135.
where's your born at, city and state?
I'm sorry?
Where was you born at, city and state?
Water County, New York, and Water County.
Working with?
Yes, I'm a teacher from Spring School. Sequoia.
And more water. You see
Oh,
water.
you want water? I thought it was
Just in case you do have a concussion, driving, when you're sick,
Okay.
it'll be exacerbated driving backwards. That's why I put you.
I didn't even think about that. I get her.
No, that's fine. Like I
I'm a
said,
pharmacist at
I'm not worried about
Parkland.
concussion. We'll go with it. You see, we'll go with it.
Sequoia. I didn't even think about that. I'm sorry. Oh, sorry. Thank you so much.
What grade do you teach?
Fourth.
I got my nephew's, Charlie DeNovo. He's a good kid.
He's very good. Sorry to be hungry.
Oh, hey, I don't apologize. So he's over there right now. Do you know if he's,
I don't know if he's still there. There's a white house. He's on first so there. He's there.
was he,
Geoffrey Paschel. G-E-R-R-Y. Paschel. P-A-S-C-H-E-L.
I'm just all over here, talking about it, sorry. G-E-R.
G-E-M.
Yep.
F-F-R-Y. Geoffrey. P-A-S-C-H-E-L.
let's go over there and see.
My dog.
That's the portion I'm talking about. And Joe, the only reason I'm asking to play it now, even though we had initially agreed that we would not be playing it, is because, I mean, the defense here is she was so belligerent drunk that she's falling down everywhere, but yet she's able to have a conversation with the officer. I'm not entering, asking to enter any of her statements. I just think the jury should be able to see exactly her demeanor and hear her as she's talking to the officers immediately after, based on their statements of her being so drunk.
Well, I don't understand the legal touchstone of belligerent. I've never said she was belligerent. In the email to Chambers, she mentioned, or to us, belligerent would open the door. I mean, the reality of the proof is they were drinking cocktails at the brasserie and were served by her friend. That is replete with hearsay, and it is overly...
I'm sorry, Your Honor, what are the actual hearsay declarations in that?
I couldn't hear over probably 60 to 70% of it, and at the office, we can't hear a lot of it.
Because I think she gave the defendant's name and spelled it. That would be a hearsay declaration. But other than that, what facts were given by the victim there that are being offered for the truth of the matter asserted?
Well, the fact, I mean, her body language, they're attending to her. Ms. Gouge keeps talking. I mean, it is not relevant under 401, under 403. We would strenuously object. I think it's impossible
What
to excise.
grounds under 403?
Because the prejudicial effect, if the court finds it's probative and it's not hearsay.
How is that prejudicial? In what way? I mean, it's very hard to hear anything she said. I mean, how is it?
She's sitting there in the corner being attended to. What is the relevance of that with the allegations of assault, kidnapping, and interference with the 911 call?
Well, Mr. Isaacs, I'll let you finish your argument. Do you have any other grounds you'd like to raise?
We object to
Okay.
that coming in.
Okay. Well, generally, there are a couple things at play here. Generally, the prior consistent statement of a witness is not admissible to bolster the testimony of that witness. An exception to that becomes if the credibility of that witness has been attacked, or if allegations have been made that she is fabricating evidence. we're in somewhat of an unusual situation here because Ms. Wilson has not even testified yet, but I think it is clear through what we've heard already in jury selection, opening statement, and during the defense cross of Ms. Gouge, that her credibility is being attacked, and it's very clear that the defense is arguing and has made statements to this jury that these things did not happen as Ms. Wilson said they happened, i.e. they were fabricated. So that's one thing. And another aspect of this is that Mr. Isaacs did directly ask Ms. Gouge what the alleged victim's demeanor was as she was speaking with the police. And Mr. Isaacs seemed to contend from his question that she was calm and composed. Ms. Gouge, on the other hand, did not think that she disagreed with that characterization. I do think at this point there are two separate grounds for admissibility of the video at this time. Number one, I think by Mr. Isaacs' questioning of Ms. Gouge regarding the alleged victim's demeanor, I think that would become admissible just to see. I think the video would be admissible at that point just to see the victim and not necessarily hear the statements that she's saying, but how she's conducting herself, how she is responding to the questions that are being posed. There have been very strong, I don't know if there's been an out-and-out statement that she was being drunk and argumentative, but you can read between the lines pretty clearly from what the defense has stated here today that they are certainly trying to paint that picture for this jury. So I think it is relevant for the jury to see the alleged victim here, to see how she was acting, how she was responding to the police. Was she intoxicated? I think the video is relevant for that purpose. And also, I do think as a separate grounds for admissibility, I think that even though she hasn't testified yet, I think that her credibility, Ms. Wilson's credibility, has been attacked to the point that the limited statements that she made that could be called factual hearsay statements, I do think that they would be admissible at this point as prior consistent statements of the complaining witness. And then the other statements that she made were made for the purposes of a medical diagnosis. She was really talking with the EMTs at that point about some of the things that had happened, and that would be accepted hearsay as well, that would be admissible. Now, Ms. Gouge is recorded on the statement, on the video, making a statement basically recounting what we have heard here today. I do not think that her credibility was attacked to the point on cross-examination that it would make her statement admissible as it's depicted on this body cam evidence. So I'm going to sustain the objection in part, overrule it in part. The state can play the portion of the body cam video that we just saw with the exception of the hearsay statements of Ms. Gouge recounting her her statement to the police. Okay. Anything else we need to take up before we break for lunch? Anything from the defense?
No, Your Honor.
Okay. We let them out at 12:45. Can we resume the trial at 1:45? Would that?
All right, you heard His Honor. Boy, oh boy, some interesting issues being brought before the court there, and us getting a real glimpse into what occurred that awful night, June the 9th, 2019, when Geoffrey Paschel allegedly brutally beat his fiancée at the time, and then took her cell phone so she couldn't call for help, as well as her computer and her keys, according to the state of Tennessee, so that she could not leave the home, her car keys, that is. But as the testimony has told us so far, according to her neighbor, she was able to escape at one point when she told her neighbor that her fiancé at the time fell asleep and she was pretending to be asleep and got out barefoot, ran for help. And that video evidence on the body camera footage raises some interesting hearsay issues. And I think it's really appropriate to discuss now on the program whether or not this should come in. Let me bring in our guests on the program today. We have trial attorney Jacob Will. He is standing by in Akron, Ohio. He practices criminal defense there. And trial attorney Imran Ansari, also a former prosecutor. He practices law in New York City. Great to see you both. Jacob, I'm going to go to you first. Tell me, as you were watching those arguments go down, we know the prosecutor wants this to come in. The defense wants it to stay out. Tell me, can you think of an exception to the rule against hearsay that should allow that video to come in?
Yes, Julie, thanks. Part of the issue when you start with unpacking that argument that we just watched was that the state is sort of correct in that the defense opened the door a little bit to some of this testimony. Obviously, the theme of this case from the defense perspective is going to be that Ms. Wilson was too intoxicated at the time the events occurred and that she somehow injured herself as opposed to being injured by Mr. Paschel. When you raise that issue of was she intoxicated, it's not even a hearsay question at that point. The video that we're talking about, this body camera that we watched, is actually just showing the state of the person in the video. Were they falling down drunk? Were they standing up? Were they able to carry on a normal, meaningful conversation? In my mind, when you're arguing this, hearsay doesn't even have to come into play for this video to become admissible because of the issues that the defense have raised so far in the trial.
Yeah, so the video can come in as long as it's authenticated, right? But then where the hearsay problem arises is with what is said on the video, the audio coming in. So yeah, it's almost like a two-part analysis. Imran, tell me, as you were watching that, can you think of an exception to allow those statements to come in as well as what's being seen visually?
Yeah, well, you heard the judge how he ruled. He sustained the objection in part, overruled it in part, and part of the audio that's going to be coming in would be the description by the victim of her injuries, because that was being given for medical treatment. That's a portion of an exception to the hearsay rule that would be allowed into evidence. And then you saw he also sustained it in part. And that would be essentially the account of the incident by the victim to law enforcement, which is something she could actually testify to in court. But I think it's interesting because, yes, the defense has opened the door to this argument that, she was intoxicated, and that was one reason why this incident occurred. And the defendant was essentially dealing with an intoxicated, belligerent individual. And with that defense, the jury does have a right to see this video, make an assessment. And I would imagine the prosecution, after having this video shown to the jury, is going to argue, you saw the victim in this case. Was she intoxicated? No, she was coherent. She was cooperating with law enforcement. And the defense's theory just doesn't carry weight.
Yeah, absolutely. Absolutely. And I was looking at the rules. I pulled them up, and because I kept trying to think of how many could you possibly argue. One of them, in addition to the one you said, is someone's then existing physical state, their condition, if they're in pain, if they've, got something physically wrong, mentally wrong, their bodily health. Those kind of statements made by the declarant, the person saying it, in this case, it would be alleged victim Kristen Wilson, are an exception to the rule against hearsay. Same with excited utterances, as we know. When you exclaim something, right? This is, in which she's in a state of panic and shock and after sustaining, what is said to be a brutal beating by the state of Tennessee. So, I'm surprised. I would, I'm not the judge, but I would argue that this should come in its entirety, audio along with the video, all of it. I think it survives against the hearsay rules as a good exception because she's describing how she felt at that time. I'm being told we're going to squeeze in a break because as we were watching that, we know the jury was eating their lunch and they're going to be back soon. Our guests are going to stay with me. We want you to do the same. This is Court TV Live, your front row seat to justice. Welcome back to Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. Great to have you with us on this Wednesday afternoon. While we are on a lunch break in our live trial in Tennessee against defendant Geoffrey Paschel, we want to turn our attention to a case that the nation has been watching. The death of Gabby Petito and the disappearance of her fiancé, Brian Laundrie. Now, he's still missing at this hour, considered to be the prime suspect in her death. She went missing in September following a trip with him all across the country, and her body was found in Wyoming. A federal arrest warrant has been issued for him for access device fraud. So to be clear, it's not a warrant for homicide, it's for access device fraud. Let me bring in now Court TV legal correspondent Chanley Painter. She's following this one for us, joins us in the studio with the latest. Chanley.
Hey, Julie. So there's some changes recently to the timeline over the last couple of days about when Brian Laundrie went missing. But as far as today, the search for Brian Laundrie entering another week at that Carlton Reserve in Northport, Florida. More of a police presence today out there at the reserve. Again, a very vast, unforgiving landscape. We see some drones, those heat-seeking drones out today in full force trying to still locate Brian Laundrie, this wanted fugitive. But let's take a look back over the last couple of months when him and Gabby in mid-June, according to the affidavit, there's been some conflicting reports as far as when their cross-country trek actually began. But according to an affidavit, it was around mid-June that they get into that white van, they go across the country to enjoy some sights of those national parks. And we move forward to July 10th on the social media. They're posting all over their social media. And on July 10th, that's when Gabby Petito posts pictures and videos that at the Great Sand Dunes National Park in Colorado. And we see her there. There's videos of them posting. If we move forward to the next timeline graphic, the August the 12th, that's when we know that we have the body cam video. Everyone has seen this, Julie, of a very distressing situation between Gabby and Brian Laundrie with the police there in Moab, Utah, that report of a domestic assault and domestic abuse. There is part of this body cam, a new part of the body cam that was released last week that gives us a little bit more of an insight of what may have happened that day. Let's listen.
Well, to be honest, I definitely hit him first.
Where'd you hit him?
I slapped him.
You slapped him first? And then just on his face?
You get to tell me to shut up.
How many times did you slap him?
Romeo, India, Alpha. Just a couple.
And then what? And then his reaction was to do what?
Yeah, until I wouldn't slap him.
He just grabbed you?
Yeah.
Did he hit you though? I mean, it's okay if you're saying you hit him, and then I understand if he hit you, but we want to know the truth if he actually hit you.
I guess, yeah, but I hit him first.
So yeah, the very haunting moments there and some of the last moments we see of Gabby Petito. If we fast forward in this timeline, again, that was August the 12th, but if we go to August the 17th, this is a new detail that we have learned, Julie, about the whereabouts of Brian Laundrie. He actually flew from Salt Lake City to Tampa, Florida during this time period, August 17th to August the 23rd. That's when Brian would fly back from Tampa to Salt Lake City to rejoin Gabby. But the family attorney for Brian Laundrie issued this statement about that trip on the 17th and basically said Brian flew home to Tampa from Salt Lake City on August 17th and returned to Salt Lake City on August 23rd to rejoin Gabby. And to my knowledge, Brian and Gabby paid for the flights as they were sharing expenses. Brian flew home to obtain some items and empty and close a storage unit to save money as they contemplated extending that road trip. And again, that was the family lawyer. That was new detail that we are learning, that he flew home and flew back during that time. And remember, just several days later, August the 27th, that is the last known sighting of Gabby Petito. Again, that's when they were spotted at the Mary Piglet's restaurant where allegedly Brian Laundrie was not happy. And he was telling the staff there at that restaurant about it. Gabby was in tears. In fact, we have a witness who posted this online. Let's watch.
We were at Fort DeSoto on the 6th. We got there at around 2 o'clock and we left around 8 because the kids had school the next day.
On the 6th?
On the 6th. We only stayed for about 6 hours.
Who was there?
My mom, my dad, my brother. We had s'mores, we had dinner.
What did Brian say anything about
We
Gabby?
had our kids there. Nothing came up.
He didn't say anything about Gabby.
No, we've told the FBI everything.
That wasn't the witness at the Mary Piglets, but that was the next part of this, which is the sister of Brian Laundrie spoke earlier this week to some protesters outside of her home. That was posted on TikTok, what we just showed, talking about how she does not know where her brother is. And this has just been such a turmoil for that family. And also something that was concerning to his sister and to us. The parents did come forward yesterday with one last statement about that timeline. They said that the Laundries first, reported that he was missing on the 14th, but they changed that. The Laundries were basing the date Brian left on their recollection of certain events upon further communication with the FBI and confirmation of the Mustang, that silver Mustang, being the Laundrie residence on Wednesday, September 15th. They now believe that Brian left for that hike to the preserve on Monday, September 13th, not Tuesday, Julie. So another little discrepancy between the parents and what they told police originally. So he would have had a 4-day head start before they actually started looking for him at that reserve, which they still are to this day.
Exactly, Chandler. I said that a couple times this show. I think he got a head start all along. What a shame. What a shame the way law enforcement has been behind on this through no fault of their own. But just because of the way this went down. That new bit of information you told us, though, I feel like this is worth just revisiting, let this sink in. He left her when they were on that trip together.
Yes, he did. And the reason for moving out of a storage building, he was gone for several days. That was a new piece of information, his attorney confirming to the media, but left her 4 or 5 days, flew back, according to the attorney, to rejoin Gabby, possibly extending their trip. But, flights, we travel all the time here at Court TV. That's expensive, Julie, to fly someplace, a round trip, to move out of a storage building to try to save money, but you paid for a flight. So still some unanswered questions swirling out there.
Yeah, but that's really helpful. I wonder what that means. I wonder if that was purposeful or had anything to do with what came next, or maybe nothing to do with it. But either way, it's interesting. Chanley Painter, thank you so much for that report. Let's bring in now our guest analysts on the program today. We have attorney Jacob Will and attorney Imran Ansari joining us for analysis today. Jacob, want to start with you on this one. What do you think? Does this new bit of information about him leaving her, going home, coming back, does that say anything to you about this? Or do you think it's really saying nothing, has nothing to do with what we know ensued after the fact?
I suppose it depends on which side of the argument you're trying to make, right? If you're a federal prosecutor, one of the things you might be suggesting is, well, he was so fed up with their relationship, there was some sort of turmoil that was happening in the moment, and he decided he had to get away from her to cool off. That's certainly one way this could be spun. Conversely, if you're defending Mr. Laundrie, if he's ever charged with a crime in this matter, or if he's ever located for that matter, you would say that it's innocuous. It was simply what the family's attorneys already said, which is he needed to get some more money. He had to save some money by shutting down this storage unit, went back to get more things for their trip, and they continued on. So I think it probably depends on which aisle you're going to be standing in when you make that position.
Yeah, really good point. Imran, tell me, anything you want to add to that question about whether or not that absence of his from their big country trip, cross-country trip, means anything?
Right. Well, I wouldn't want to speculate, but I would imagine it's just what's interesting to me, though, Julie, is the way the details are trickling out and how there are changes in that timeline. Because we now know through the statement through the parents that he had a head start. Now he is leaving on the 12th. The changes in those details are interesting to me because those are the sort of details you would think that law enforcement have already gone through and also the family would be sure of. So I would think that would be problematic. If Brian Laundrie is found and they are able to tie him with this homicide, it's those details and those timelines that are going to be very important. And the whole notion of the flight would go to a consciousness of guilt. And I think that's what's going to be really interesting here. If he's apprehended, the way the defense would have to counter an argument from the prosecution if he's charged with the homicide of consciousness of guilt. Whether the trip back from Utah to Florida is indicative of anything, I think it remains to be seen. But again, I think the timeline and the way things are changing is interesting, and how it will play out if and when Brian Laundrie is found.
Yeah, I'm glad you brought that up, Imran. I know you know that instruction well, having served as a prosecutor like me. If you have that in your jurisdiction, it's a great tool to use. And boy, oh boy, in this case, I'm sure they will use that if they're able. Imran Ansari, Jacob Will, thank you both very much. I'm being told we have to take a break because we're nearing the bottom of the hour. When we come back, lots more legal analysis and live coverage for you is ahead, and the jury will be back in Tennessee to hear more of the domestic violence case being brought against Geoffrey Paschel. We'll be right back. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. On Tuesday, we spent a good part of our afternoon watching the latest hearing in Wisconsin for accused Kenosha shooter Kyle Rittenhouse. And Tuesday was supposed to be the final hearing before the November 1st trial start date. But now, the judge overseeing the case has scheduled yet another pretrial hearing. The defense lawyers want a use of force expert to testify on Rittenhouse's behalf at trial. Now, the defense team claims that Rittenhouse was acting in self-defense when he shot 3 people, killing 2 individuals and injuring another in the 2020 protests in Kenosha that started over the shooting of Jacob Blake. Use of force expert John Black spoke at Tuesday's hearing. There was held what is called a Daubert hearing, where the judge essentially evaluates the proposed expert's testimony and then decides whether or not it's admissible at trial. Let's take a look back together at some of what he told the court.
After this individual strikes Mr. Rittenhouse with his skateboard, he does what?
He continues to stay engaged with him. So this wasn't just a run by and, this isn't like running through the sprinklers and getting wet and then coming back out. This person is, after he does the first, we'll call it a strike with the skateboard, hard wooden, think about getting swung out with a bat. But the fact is, he's taking his body weight with both knees and staying on Mr. Rittenhouse. Now, I think that's interesting because this would be indicative of him or an assailant as a way of establishing control. Whether you're a student of ground fighting, whether you've been trained in a civilian police academy, whether you've been trained in anything, the idea of putting knees down on somebody to use it as a way to potentially pin them or control them are techniques that are commonly taught.
And as he places his knees on Mr. Rittenhouse's chest, does he do anything with the hand that doesn't contain the skateboard?
Well, he's, and this is the ongoing part. So we have a strike. We have a attempt to control. And so the question is, what's the goal of this? Well, you can see that in the video that the left hand of the assailant is now beginning to go the body line. It's beginning to drop below the body line. And so the question is, what's down there and why would his hand do that? And my argument would be is if that hand is down there, that hand is potentially going for the weapon, going for the firearm.
That individual has a firearm in his hand, correct?
Yes.
Describe the interaction between Mr. Rittenhouse and assailant number 3.
Yeah, there's a lot of stuff going on in here, and one in particular is we've got the approach. So the first thing is assailant number 3 closes distance. Now, we talked earlier about context. He closes distance with someone that has been wrestling over a firearm and up to this point had discharged his weapon multiple times, that we would argue that assailant number 3 would have been aware of this. They've seen the idea. Now, at the same time, he hasn't sprayed the crowd. He hasn't done anything.
When you refer to he, I'm sorry to interrupt, but when you refer to he, who hasn't sprayed the crowd?
And absolutely correct. That's my fault. Kyle Rittenhouse has not taken his firearm and basically just pulled the trigger without any regard to anything and just sprayed the crowd as a vernacular to get back. But he has had very directed fire, deliberate choice in very specific context. The specific context would appear to be, I need to maintain control of my weapon.
All right, so at the end of the day, yesterday, the judge did not end up making a decision as to whether the use of force expert will be permitted to give testimony at trial. We know there's another hearing, as I told you, scheduled for October 25th, where the court will be hearing from a use of force expert offered by the prosecution. And so here we have the prosecution saying we don't want the defense to introduce this expert, but if you're going to allow him in, we want to bring in our own use of force expert, which I would say is a smart idea. Let's bring in our legal analyst guests and see what they say about it. Trial attorney and former prosecutor Imran Ansari joining us from New York, and criminal defense attorney Jacob Will joining us from Akron, Ohio. Imran, let me start with you, please. What do you say about this? Should the judge allow this defense expert in your opinion?
Well, we had a preview of what Judge Schroeder may rule in this case because he had stated previously that he doesn't want any competition in the courtroom in terms of explaining the law as it relates to justification or self-defense to the jury. So whether he now, after conducting this Daubert hearing with this witness, believes that it may cross the line, and other than giving that expert witness testimony to the jury may be somewhat blurring the line and instructing the jury on the law of self-defense, then I think that he's going to stick with what he sort of previewed previously and not allow and preclude this expert from testifying in court. Of course, now the prosecution, if their motion in limine to not allow this testimony before the court and preclude this witness from testifying, if that is overruled and denied, well, then they're going to be bringing their expert in. And ultimately, Julie, it's going to be a battle of the experts talking about whether the use of force was justified in this instance. But again, I think Judge Schroeder had it right in the beginning where he said in regards to justification and the law of self-defense, it's ultimately his job to give that law to the jury and not an expert.
Gotcha. Imran, thank you. Jacob Will, tapping into your criminal defense experience, tell me the defense argument why the court ought to allow this expert in.
Thanks, Julie. One of the first things you're looking at when you're talking about an expert in a Daubert hearing is, does this expert provide information that a normal layperson would not possess? And further, if they don't possess it, would the expert that the side is presenting help them understand something about the case? So in this case, where, with Mr. Rittenhouse, we're looking at an expert to talk about use of force and was the use of force reasonable? One of the big issues that the defense is going to face, regardless of which way the judge rules, is it's going to be unlikely that they can get their expert to opine on the ultimate issue. Specifically, can he say that what Mr.
Oh, I think we might have just lost your connection there, Jacob. Well, the ultimate issue would be whether or not the force was reasonable, as we know. So, Imran, I'm going to kind of go to you on this one. At the end of the day, when we're talking about a self-defense plea, you've got to be in fear of imminent death, serious bodily injury in order to have a homicide that's justified. So essentially, that's what we're looking at here. We know these 2 homicides occurred. We know 1 other shooting occurred in which the person shot survived, but at the end of the day, wasn't it reasonable or not is going to be the question for this jury. And Jacob, and I believe we might have him back. I'm being told his audio might have reconnected. Jacob, can you hear me?
I can hear you, Julie,
all right.
yes.
So pick up where you left off. You were talking about the question of reasonableness. Imran was ready to step in for me there and help out, but I want you to finish your thought. We lost you where you were saying whether he'll be able to give an opinion to the ultimate issue, and then your audio went out.
Thanks, Julian. Sorry for that.
That's okay.
Yes, ultimately, can the expert opine on whether what Mr. Rittenhouse did was reasonable in terms of self-defense? Those issues are traditionally left to the jury. That's why we have the jury trials in the first place. So I would be very surprised if the judge were to permit this expert to testify in full the way that the defense would want him to, because the ultimate conclusion is something that the jury ultimately has to decide.
Gotcha, Jacob. Well, thank you kindly. Imran Ansari, thank you too. So we know that in Tennessee, where we've got our next live trial that just began a short time ago, the judge told the jury to be back at about 1:40-ish, 1:45. So no one's in the courtroom quite yet, but we're going to squeeze in a break and hope they're all ready to rock and roll when we come back. This is Court TV Live, your front row seat to justice. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Before we head back into live court, I want to draw your attention to another major case we've been covering for you. In particular, we've assigned Court TV legal correspondent Julia Janae to follow the latest developments in the case of the killing of Ahmaud Arbery. And in a Court TV exclusive interview, Julia spoke to those most deeply affected by the incident, the family of Ahmaud Arbery. And you will be able to watch Julia's full exclusive interview. I thought we might have had a preview for that of that interview for you, but apparently we can't roll that right now. The special is called The Arbery Family Speaks. It'll air this Friday night at 7 p.m. Eastern Time, 6 p.m. Central Time, right here on Court TV Live. Don't miss it. And just want to let you know that we are waiting and monitoring things in the courtroom in Knoxville, Tennessee, where former reality TV star Geoffrey Paschel is on trial for domestic violence. He is accused in a June 2019 incident where he is said to have brutally beaten his fiancée at the time. They are no longer together, and we've had one witness testify in the case so far, a neighbor of the victim in this case. She's what we call in the law an outcry witness. She was the one who placed a 911 call when victim Kristen Wilson came to her home and said she had been assaulted by Geoffrey Paschel. Let's take a listen now to some of that being played this morning in the courtroom.
Where your emergency? I have a neighbor that was beaten. Okay, where I have a neighbor that's been beaten. We're at 15. We're on 501 Aldenwood Lane. Okay, and where's the person who hit her? He is 2 doors down at 1425 Aldenwood Lane. Her dog is there in the house, and she's concerned about her dog. She is severely beaten. Does she need an ambulance? Came to my house. She does not need an ambulance. I don't think. She has a head trauma. Okay. So, yeah, we're gonna. Very large knot. Okay. I'm very concerned. Okay, we're gonna get them. Are you there? I'm here. What's your name? I'm Lauren Gouge. Gouge is my last name. Okay, who hit her? Her boyfriend.
Okay, so that was a little bit we heard from the neighbor, the first witness called in this case, gave some testimony. Her name is Lauren Gouge. And after the jury was sent out for lunch, we saw some arguments back and forth about whether body camera footage from when police responded to Lauren Gouge's home and spoke with her and spoke with the alleged victim, Kristen Wilson. And there was an objection to the hearsay on that. And so to be clear, the court made a ruling on this one saying that the tape will be partially redacted. So the jury will get to hear the part where Kristen Wilson speaks to police. Great ruling by the court. And then the court will have excluded the neighbor talking in the beginning of the tape because there's no hearsay exception for her statements. So great ruling by the judge there. We will be seeing that officially introduced into evidence as this trial progresses. We got a preview of it when the jury was out of the room. Let me bring in, for some reaction to how this trial is going so far, our guests on the program today, trial attorney Jacob Will in Akron, Ohio, and trial attorney and former prosecutor Imran Ansari in New York City. Jacob, let me go to you. I know we need to let you go at the top of the hour. So what did you think about the opening statements each side presented? What did you like? What didn't you like? Please.
Yes, Julie, thanks. From watching this defense opening statement, and as a defense lawyer, it was natural for me to gravitate towards that. I'm interested in how the evidence is going to play out, because from the defense perspective, there was no physical altercation whatsoever. There was much made during the opening statement by the defense about the number and quantity of drinks that had been consumed, or cocktails rather, as in the parlance of the Knoxville area, about how many they were drinking that night when they were at dinner. Then we also heard in the opening statement how she was so intoxicated that she ran out of the house and hit her head on the door or on the wall when she was leaving. The concern, of course, from the defense perspective is that if you can't show anything to connect your statements to the evidence that's actually presented, you run the risk of not being able to connect with the jury. You run the risk of the jury thinking that you're blowing smoke at them. And so from that perspective, I am concerned a little bit, especially after we saw portions of the video that you just referenced that will be played after lunch, where it does not appear as though she's intoxicated when she's interacting with the police officers that arrived on scene.
Really great point you just made, Jacob. Thank you for that. Imran, give us your assessment. The state's open, the defense open. What did you like? What didn't you like, please?
Yeah, well, I agree. Well, you never want to overpromise in an opening statement, because if you don't deliver during trial, usually the jury is going to look at that and wonder what the problem was. Is there a credibility issue with the evidence that you're presenting? Is there a problem with the argument that you presented? And you never want to overpromise. I think that the prosecution has a good case here. They have the footage now that is going to come into evidence, and that will somehow refute that defense theory about intoxication of this victim. You have the injuries that were on the victim that are somewhat corroborate the assessment of the actions of the defendant here, and you have the defense opening statement, which somehow now may ring a little hollow if this evidence is assessed, the video is assessed by the jury, and that argument that she was belligerent and intoxicated doesn't really show on that video. So I think the prosecution has a strong case here, and I think the opening statement was indicative of that.
I like what you said there. Absolutely. Ring a little hollow for sure. Jacob, let me go back to you because we still have some time here. Let's pick apart, if we can, the cross-examination that defense counsel did of the first witness, because we know the prosecution kept it really short and tight. They drew out the facts they needed to draw out, that Kristen Wilson had gone to Lauren Gouge's home barefoot, panicked, looked, in her words, severely beaten, and to have head trauma, said it was Geoffrey Paschel who did it, described what he's wearing, all of that. And then on cross, I was hoping, you're the defense attorney, not me, but I was hoping he would just stand up there and say, you didn't hear any commotion that night, did you? No. You didn't see anything, did you? No. So you didn't personally witness my client striking Ms. Wilson, did you? No. Okay, so you can't look at this jury and tell them what happened, can you? No. Thank you, ma'am. But instead, he didn't do that. He decided to get up there, and for me, she gave even more facts through him than she did with the prosecution. I was cringing. Tell me your reaction, please.
Julie, you're absolutely right. I had the same concerns. Typically, in a witness like this, there's not a lot of harm they can do to your client as the defense lawyer. You want to get in, get out, make your few points that you just raised. Those were the exact questions you'd want to ask, and then sit down. What happened here, though, is that he almost had the victim testify twice. He was asking questions designed to elicit her responses to the neighbor, to Miss Gouge, and really, it's going to give an opportunity for the state to put on that evidence two separate times, once with the neighbor and then once again with the actual victim, Miss Wilson. So it's a concern, and obviously they're going to have to maybe adjust to that strategy in the middle of this trial.
Yeah, well said. Jacob Will, always great to have you on the program. Thank you so much. I know we need to let you go. Imran Ansari, thank you. You're going to stay with me, and we want you to stay with us at home as well. We're going to squeeze in a break because the jury is not back in Tennessee. But as we go to break, I want to share some breaking news. This just in to our Court TV newsroom. This is coming out of California. Defendant Scott Peterson will be resentenced for the death of his wife and unborn child. He was convicted back in 2014, you'll remember, for murdering his wife, Lacey, and the child she was carrying at the time of her death. This was in 2002. He was sentenced to life in prison, but that sentence was overturned last year. Now he's going to be sentenced on December the 8th. Stay right here with Court TV Live. We'll be right back. are watching Court TV Live, your front row seat to justice. I'm Julie Grant, and it's great to see you on this Wednesday afternoon. We've got a live trial for you happening in Tennessee, and we are waiting for the jury to come back from their lunch. In the meantime, I want to tell you about another case that we're covering for you, this one in Florida, the battery trial of alleged Parkland school shooter Nicholas Cruz. The jury selection is happening right now, and to be very clear, this is a case that is separate and apart from the Parkland school shooting. In this case, the defendant's accused of attempted aggravated battery on a law enforcement officer while in custody. So this was some video taken earlier today. The court recessed for the day. The way they're doing this voir dire, because he is a defendant whose name has been in the headlines for years, they're doing a big group voir dire, bringing in panel after panel, pre-qualifying those jurors in a group voir dire setting, and then they're going to be returning to do the individual voir dire. So this is taking a lot longer than it ordinarily would in a case of this nature with a defendant that is not known nationally. And this case is being tried purposefully by the state prosecutors before the Parkland shooting case, even though it happened later in time. And the reason for that is if the state gets a conviction on this case, and if they get a conviction on the shooting case, they can use the conviction in the battery case as an aggravating factor in the penalty phase of the shooting case. So that is why these are being done out of order, and we're going to continue following that one. We have our crew there in Florida where this is happening. And the other case we're following for you live here on Court TV is happening in Knoxville, Tennessee. If you're just joining our coverage, we welcome you this afternoon. The defendant formerly starred in a reality show on TLC called 90 Day Fiancé Before the 90 Days. And so far today, you've heard opening statements from the prosecution, from the defense, and then we saw the first witness called. And now we see the judge taking the bench. Let's go in together live.
Very enjoyable lunch. I'll give juror number 9 a second to get that thing reassembled. Take your time. There we go. Ma'am, we do have a battery pack charging for that thing, so if it starts to go out, just get my attention and let me know, and we'll get it replaced for you. Okay? General, you ready to call your next witness?
Yes, Judge.
Go ahead, ma'am.
Okay, call Kristen Chapman.
Ma'am, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat.
Go ahead and remove your mask if you want to. Can you state your name for the record and spell your last name?
My name is Kristen Chapman, C-H-A-P-N, and my maiden name is Wilson, W-I-L-S-O-N.
And when did you get married?
In October of 2019.
And so in June of 2019, were you Kristen Wilson at that point?
Yes, I was.
Okay. Ms. Wilson, do you know Geoffrey Paschel?
Yes, I do.
And how do you know him?
He is my ex-fiancé.
And do you see Mr. Paschel in the courtroom today?
Yes.
Could you point to him for us?
Yes, he is right there.
And could you just tell us maybe what color shirt he's wearing?
Blue shirt and gray jacket.
And if we could have the record reflect she has identified the defendant. How long were the two of you dating?
A year and a half, and 3 months of that was the engagement.
Okay. So in June, specifically June the 9th of 2019, you all were engaged at that point?
Yes, we were.
Were you living together?
Yes. He had a lot of stuff at my house, but he still had his residence as well.
Okay. And I want to talk to you specifically about the events of June the 9th, 2019, okay? Do you recall that day?
Yes.
Now, I want to back up before the early morning hours. What had the two of you all done the night before?
We had gone to dinner.
And I'm going to have you, maybe you'll just pull that up.
Sorry.
Soft-spoken.
Just keep hitting this trash can. We had gone to dinner at the North Shore Brasserie. We were there for several hours. We had drinks and dinner, and when we left, we went back to my house. We had plans to go meet a friend at Roosters, which is right near my house in Rocky Hill. So we stopped to let my dog out, and I walked her by myself up the street to the cul-de-sac while he stayed at my house. And I returned home. I walked back up the street. I texted my friend Katie and told her that we were leaving and we would see her shortly. She was also on her way there. I remember sending the text message. I remember exactly where I was standing in the street in front of my neighbor's house. And I remember walking back up the driveway. But the next thing I remember, he was beating me.
And when you say he, are you talking about Mr. Paschel?
Yes, Geoffrey.
So just to back up a little bit, do you remember what time it was you all got back to your house?
It would have been around 11 o'clock. Because I texted Katie at 11 o'clock saying we were on our way, so 10:45, 10:30, 10:45.
Okay. And you said you all had dinner and drinks. What were you
Yes.
drinking?
Champagne.
Do you recall how much you had to drink?
I recall that I had 3 glasses of champagne.
Who was driving that night?
I drove.
Okay. And did Mr. Paschel have anything to drink?
Yes.
And what do you recall what he was drinking?
Double whiskey and Cokes.
Okay. And so when you get back in the house, you said, tell us exactly what you remember as soon as you get back into the house after walking the dog.
After coming up my driveway, the next thing I remember, I was on the floor in front of my staircase that leads to the upstairs, and he had me by the back of my head and was hitting my face into the floor, and I was screaming for him to stop.
Okay. Is that all that happened, or?
No. From there, he dragged me up the stairs. It's not quite a split level, but there's like 4 stairs that lead up to the bedroom, and it's hardwood floors, and he was dragging me by my head and by my hair. He had me kind of by the back of the neck, and we went up the stairs towards the bedrooms, and I blacked out again. I lost consciousness.
About how long did all of this take place, if you remember?
If my best estimate would be about 30 minutes.
Okay. And during that time, did you try and get away or anything?
When I was screaming, I was trying to get away from him, but I couldn't. He's too strong. He was holding me down on the ground, and then he was pushing me around, and I could not get away.
And so after the physical attack stopped, what happened?
So I remember going up the stairs, and then that's the last thing I remember. I don't know what happened up there, but there's blood splattered down my bedroom door, so something happened up there. The next thing I remember, I was in the corner of my kitchen, and he was shoving me up against the wall, and then he got me back down on the floor in the kitchen and was hitting my head on the floor in the kitchen, and I lost consciousness again. The next thing I remember, when I regained consciousness, I was sitting on my couch in my living room, and I was looking at a wall. They've got front windows, and then there's a wall next to it, and there was blood splattered down the wall. I don't even remember being against that wall or it's in a corner that I don't remember being in, but I was sitting on the couch, and my face was dripping blood down my chin and onto my couch, and he was pacing, not saying anything, but just pacing behind the other end of my sectional, which had been overturned, flipped upside down.
And at some point, did you go upstairs to the bedroom?
Yes. Eventually, he stopped pacing, and he told me to go to bed, to get up and go wash my face and go to bed. So he followed me up the stairs into the bathroom, which is right next to my bedroom. And he wouldn't turn the lights on, so I couldn't see my face. It was dark. He made me wash my face. He grabbed a piece of toilet paper and handed it to me and told me to blow my nose. to get the blood out, and then he flushed that down the toilet. And then said, go to bed. And I did, because I didn't want it to continue.
And when you say it,
The abuse. I mean, if I told him no or I tried to get away, he was 100% going to start hitting me again, forcing me.
did you have a cell phone or anything at this point?
I did own a cell phone. I didn't know where it was during this whole situation. When I laid down in bed, he had my phone, and he also had his MacBook. He also had his computer. And he sat on the other edge of the bed on the opposite side, and I was pretending to sleep and trying not to lose consciousness. I was just really focused on staying conscious because I knew I had to get away at some point, or I didn't know what was going to happen. So I kept kind of opening my eyes a little bit to look and see what he was doing. And he had my phone. He was in my messages. I saw him in my social media accounts, especially my messages of my social media accounts. He had deleted a bunch of voicemails once I finally got my phone turned back on. It's essentially like he erased every trace of him through my phone. Every message, he deleted our whole text conversation, so I didn't have any of that. And this went on for somewhere between an hour and 2 hours, and I was just trying to stay conscious. Eventually, he had the sound on the phone, so when he turned the power off, like when he locked the screen, I heard it, and I heard him set it down on the bedside table on that side of the bed. And he tried to console me, like came over and put his arm on me and was trying to apologize and touch me, and I told him not to touch me. And as soon as he laid down, stopped moving, and got situated on his side of the bed, I jumped and I ran. I ran straight out the front door, and I went straight to Lauren's house.
And when you ran out the front door, did you grab anything, or did you just take off?
No, I just took off.
Did you have your car keys?
No. No, he had my car keys.
I'm sorry, say that again.
He had my car keys. I found out later when I got home to get my stuff, he had my car keys.
Okay. And what did you do when you went to Miss Gouge's house?
Asked her to call 911.
Okay. And did you wait there until the police came?
Yes, I did.
And did the police come out and take pictures of your injuries?
Yes, they sent a forensics officer to take pictures of the injuries. They'd sent an ambulance as well, I believe, but Lauren ended up taking me to the hospital because it's the hospital she worked at. And the officer said it was okay that she did that, so they let me go with her.
Now, Gretchen.
Matt?
Ms. Chapman, can I show you some photos? Look at those for me. And tell me, do those photos fairly and accurately depict the injuries that you sustained that night and everything that you've been talking about?
Yes, they do.
And do these appear to be the photos that were taken in Ms. Gouge's kitchen?
Yes, this is Lauren's kitchen.
Your Honor, at this time, I would ask that these 10 photographs be the next numbered exhibits.
Supposed to be collective, or?
I've went ahead and pretty much them just individually, just in case we wanted to talk about any of them.
Okay, so that'll be 3 through 12? Okay, any objection?
No.
They'll be received.
And that published,
You may.
Okay, so the area of your head there, your forehead, is that, can you tell us how that injury was caused?
That was him hitting the front of my head into the floors in front of the stairs.
Is that another angle of that?
Yes, yes it is.
And then here, tell us what's on your elbow and forearm there.
So my bet, I can only assume this is from being dragged. I have the same marks on, or similar marks on my knees, and it felt like rug burn. So, yeah.
And is that the area of your knees there?
Yes.
I'm not. And then lip there. And then just for purposes of the record, is this your back area?
It is my back, yes.
Again, is that your back?
Yes, it is.
Do you recall how those came to be?
Just being shoved into walls and furniture repeatedly.
Just another side view of your forehead there. Get the lights back on. Did you, so you did go to the hospital, correct?
Yes, I did.
And were you diagnosed with anything at the hospital?
A concussion.
Sorry, what was that?
A concussion. Yes.
Yes, ma'am.
Do you recognize these documents I'm handing you there? You may need to flip off the first page there.
This looks like my medical records from Park West from that night, but I've never seen this before.
Okay.
You can have it, yeah.
Judge, at this time, we would ask that this be,
Well, Your Honor,
13.
in this instance, since the witness did not identify those, we would object to their admissibility and ask that they just be marked for ID.
Judge, we approach.
General indicated the affidavit of the custodian is attached here. So what's your response to that?
I agree that I'm surprised that she says that she can identify those as her medical records.
Well, she didn't really say that. She said that they were her medical records, but she didn't say that.
They say a picture's worth 1,000 words. And these jurors just saw such a story through those photographs of this alleged victim with that knot on her forehead, as the prosecutor described it, the size of a fist, her bloody lower lip, the bruises on her forearm, her elbow, her leg, and her back. The ones on her back, she said, caused by repeatedly being shoved into furniture. That big knot in the middle of her forehead She said being caused by her head being bashed against the floor right by her front set of stairs in her own home. The home that she said she had to escape that night or she didn't know what else was going to happen. She said it was all done at the hands of this man who at the time was experiencing lots of fame on the show 90 Day Fiancé. And I would like to know when the show was taped, too. That's something we can look into because we know this incident is said to have happened in June of 2019, and we know that fans of the show were so outraged at these allegations that surfaced while the show was airing that they petitioned to have him off that final episode where all of the stars tell all, and they didn't want him there just based on those allegations because they are so horrific. Let's go back in live.
Did you also, the following day, did you go to the Family Justice Center here in Knoxville?
I did, yes.
And did they take some additional photos of your injuries?
They did, yes.
May I approach, Judge? These photos I'm handing you appear to be accurate copies of some of the photographs that were taken at the Family Justice Center.
Yes.
All right, let's not do that. See the next number of exhibits. There are 20 photographs total.
Any objection?
No, Your Honor.
14 to 33.
Should be 14 through 33. Let me receive.
Permission to publish, Judge.
You may.
And what are we looking at in this photograph here?
That is the back of my neck.
Okay, and do you recall how those injuries were sustained?
I was pushed into a wall pretty hard, so I would assume that's where that came from.
I'm just going to go through some of these. Did your face, the injuries to your face, did they kind of evolve over the days following?
Yes, they did. That's why they had forensics come back out and take pictures because the bruising had kind of changed.
Bruising on your hands?
Yeah, from catching myself or attempting to catch myself. Both of my palms right there were bruised.
Did you take some photographs on your own phone in the days following, even after these were taken?
Yes, I did.
Did you also take some photographs of some of the things that you saw in your house?
Yes, I did.
At this point, we would object based on its cumulative and would not be relevant under 401. We've seen pictures from the night of and the day before. So unless they're different injuries, we would object.
Okay, I guess, let me take a look at it if you guys would approach. And while they're approaching, I might have missed this, man, but when were the pictures taken at the Family Justice Center?
Everything happened on the 9th, which was a Sunday. I went the 10th, which was a Monday.
Okay.
June 10th.
Thank you, ma'am.
Yes.
What I find to be the most terrifying thing about domestic violence is not only are they crimes of violence, but they are crimes of secrecy. And the face that batterers often show the world isn't the face that they show the person they're abusing. Now, Geoffrey Paschel is the accused in this case. He sits there cloaked in the presumption of innocence. And it will stay that way unless and until the state of Tennessee proves him guilty beyond a reasonable doubt. And if these allegations made by Kristen Chapman, his fiancé at the time of this alleged incident, are true, if they are true, I want you to just think for a moment how tough that is to go into a public courtroom and tell the world about someone grabbing your neck, bashing your head against the floor, beating you so badly you black out, all in your own house, and you can't call for help because this person has taken your cell phone, unbeknownst to you, also taken your car keys, deleted himself from your social media so there wouldn't be a connection from things in your phone. Secrecy, and it's sinister. These allegations are so sinister that this woman is making against the man that she loved, that dated her for multiple years. They were planning to be married. All of this happening back in June of 2019. And although she's quite composed today, I just want to make the point how difficult it is for survivors of domestic violence to speak about what's happened to them. Now, Geoffrey Paschel maintains his innocence here, saying that he didn't cause all these injuries the jury just saw displayed on those photographs, saying through his attorney in opening statements that she injured herself as she was leaving the house, and the jury will be the judge. Let's talk a little bit about what the jury might be thinking after seeing these awful photographs. Let me bring in trial attorney Imran Ansari, standing by in New York. He also has experience as a prosecutor. Imran, tell me your thoughts after seeing these photos, please.
Sure. Well, Julie, this is the moment where the jury really gets to see the viciousness of the allegations that this defendant is facing. And you saw the photographs, and it appears that this was a brutal beating. And the victim has that confidence of taking the stand. And you mentioned it's a very hard thing to do, a victim of domestic violence like this, to take the stand, face her abuser, and testify in open court. And we see that she's doing that with confidence and composure, while the jury is also seeing the photographs of her injuries, and it seems to be brutal. And now the defense is putting forward this argument that she was belligerent and some of these injuries were self-inflicted. I'm going to go as far as to say that they don't really comport with self-inflicted injuries. They seem to be consistent with that of trauma inflicted by another. And I think that the jury, seeing these photographs, with the prosecution's argument, with the testimony coming out here in court, will find this a compelling case for the prosecution. Of course, we have yet to see the cross-examination of this witness, but I think right now, in terms of the prosecution's case, in terms of the photographs that they see, it's really corroborating the story of a brutal assault here.
Oh, I'm with you. So well said, Imran. Thank you for that. And drawing on experience as a former prosecutor, and I'm sure you know this too, Imran, and I can't stress it enough when we talk about DV. DV is not about anger management. It is not about somebody who can't control themselves and has outbursts and engages in beatings because they're just so enraged and they can't help themselves. No, it's about power and control, methodically controlling their victim through using violence. And when she told that story, all I kept thinking of is the word control. When she said he grabbed her by her neck, control. When she said that after he bashed her head on the floor and she blacked out, control. He dragged her up the stairs, control. She said then he made her wash her face, forced her to wash her face, control. Forced her to blow her nose, control. Forced her to go lay down in the bed, control. As she was saying that, I was getting chills up and down my arms just thinking about what she says she endured. Imran, tell me, I mean, you know about DV. I mean, having been a prosecutor, you understand the dynamic. Were you thinking the same thing here?
No, absolutely. Her, recounting that harrowing experience, you really get the sense of her being trapped, as you said, being controlled. And the way she states that she went along with it, she blows her nose, she cleans herself up, and that idea of the abuser directing the victim to clean themselves up and just go to sleep, it really sort of resonates, and I'm sure it resonated with this jury. And the way she said that she went to sleep because she just wanted to avoid further assault, further abuse is really compelling. And I think that her account of it will resonate with this jury as this trial continues.
Oh, I agree, Imran. It looks like they're done with the sidebar. Let's listen in together live.
Did you also take photographs of the way that your house was after the attack?
Yes.
Did you observe anything? I think you mentioned earlier that there was some blood spatter. Did you take photographs of those as well?
Yes, I did.
And would you recognize those photographs?
Yes, I would.
May I approach, Judge? Do these appear to be the photographs we were just talking about?
Yes. Yes, they are.
And did you take those with your personal cell phone?
I did, yes.
All right, this time we would ask. It's pre-marked as 45 through 52. We enter the next exhibits.
Objection. Same objection.
They'll be received.
And may I publish all of those that we just went through, Judge?
You may.
What are we looking at in this photo?
There was blood dropped on each of my stairs, and that's what that is.
And how many stairs, again, did you say there were from the living room to the?
There are 4 leading upstairs, but these are actually my stairs leading downstairs.
Okay. And what is this?
That is a wall in my living room.
And what is the substance that we're looking at there on the wall?
That is my blood.
And this one?
Is a Yeti cooler, again with blood on it. That is the wall in the kitchen with the blood splatter on it.
It's
And
kind of
that
hard to see
is
this one, but.
my kitchen floor, yeah, with the droplets. That is a light switch in my living room.
And is the substance that we're looking at?
Is blood, yes.
That one. And then is this photos of your injuries in the days after?
Yes, it is. That's actually right, when I got home from the hospital.
Okay.
That is also right when I got home from the hospital on the morning of June 9th.
What number? Can you make that for this record?
Yes, Judge, I will. just looked at the photograph of your forehead there that's been marked as Exhibit 34, and you said that that one was right after you got home from the hospital.
That's correct.
And then the photograph of your neck here that we're looking at
Is also
before, that was marked as 36. That was also, okay.
Yes.
What is this? Is that your leg?
It is my leg. That was taken at my parents' house. I can't recall the date off the top of my head.
Was it in the few days after?
Yes, I stayed with my parents. I did not feel safe in my home, so I went and stayed with them for several weeks, if not months.
Mouth again there. Your foot. And then right up there at the top of your foot, kind of at the bend of your foot, is that where your skin is peeling there?
Yes.
Pull these just to make sure. Not making it about that. All right, I'm gonna pull up the photo of what's been marked as 35 here. Is that the days following? Just again, another photo of your face there.
Yes.
Ms. Chapman, where is your home located? What was the address?
1425 Aldenwood Lane.
And everything that you have described to us today, did that all occur in Knox County?
Yes.
Okay. Judge, I will pass the witness at this time.
Thank you, Jim. Cross-examination.
Thank you, Your Honor. Good afternoon, Ms. Chapman.
Good afternoon.
My name is Gregory Isaacs, and I represent Mr. Paschel. Starting in 2017, you and Mr. Paschel became an item. You began going out, is that correct?
Yes.
And you became a couple, and shortly thereafter, you both decided to be monogamous, correct, as it related to that relationship?
No, I don't recall that.
You don't?
Well, I recall us being monogamous, and then in April, I found out that he did not feel the same way. So we did break up for a little bit in April. That would have been of 2018.
And that created some tension, correct?
Yes, we broke up because of
throughout
that.
the course of the relationship. But during the course of the relationship, it progressed, and you would do things that normal couples would do, correct?
Yes.
Go out to dinner, correct?
Yes.
Take trips, for example, to Florida, correct?
Yes.
Geoffrey was involved in your life, correct?
Yes.
He would go to activities and support you in your capacity as a teacher at the fourth grade teacher at the Sequoia Middle School, correct?
Elementary.
Elementary school.
Yes.
And by and large, the relationship progressed and became closer, correct?
Correct.
And prior to June of 2019, those months leading up to there, Geoffrey asked you to marry him, correct?
Correct.
And you said yes.
I did.
Yes. And so at that point, you were his fiancée,
Yes.
and the relationship at that point continued to progress.
Yes.
And let's fast forward to June of 2019. At this point, your relationship with Geoffrey is good, correct?
Yes.
You knew if you were married, you were going to have a blended family because Geoffrey had a number of children, correct?
I knew of about a few of the children, not all of them.
So he supported you in your position as a teacher in elementary school, correct?
Yes.
So basically, other than issues of infidelity, in June of 2019, nothing could be better as it relates to Kristen and Geoffrey, correct?
Other than infidelity and lying about children and ex-wives that I didn't know about, then yes.
Made you mad, didn't it?
We broke up over it, but this was all again prior to the engagement. This all happened in January.
Yeah. So let's fast forward or rewind, depending on where we are, and go to June 9th of 2019. Started out as a normal Saturday night. You go out to dinner, correct?
Yes.
About your restaurant on a Saturday night, correct?
I would say that's normal for couples to do, yes.
And Geoffrey came to your house, which is also in North Shore, at approximately 6 p.m., correct?
No, he had been at my house all day that Saturday.
All right, because you guys were basically living together at that point in time, correct?
Yes, he was staying at my house then.
And let me kind of rephrase that question. So when you all left for dinner to go to the brasserie, which is just a few minutes away from where you live, it was about 6 o'clock, correct?
I'm assuming sometime around then. We were there for several hours.
Yeah, so if I showed you your prior testimony and you said it was about 6 o'clock, would that refresh your recollection?
I believe it was about 6 o'clock.
How far is the brasserie from your house? 5 minutes, 10 minutes?
5 or 10 minutes, yes.
Yeah. So if you left at 6, y'all got there, you missed the Saturday night rush, so you would have gotten to the brasserie restaurant about 6:15, 6:30?
Yes.
Now, also at the brasserie that night was a close friend of yours that was the server, correct?
Yes.
And you mentioned her name when Ms. Good was doing your direct examination. Tell the jury who that friend was.
Katie Meyer.
And Katie Meyer was a server, correct?
Yes.
And your relationship to Katie Meyer was what?
At that time, she was my brother's girlfriend.
Your brother's girlfriend. And we have spoken about this before, but Ms. Myers didn't give you drinks that were fairly strong, correct?
No.
That's not correct.
Katie did not give us free drinks.
Did she make drinks that were stronger than what would have been normally poured as required by the Metropolitan Drug Commission and the protocols at the brasserie?
I would say no. I was drinking champagne, and it was served in a champagne glass, so can't really make that stronger.
You were drinking champagne.
Correct.
Mr. Paschel was also drinking.
Yes.
You get there at 6:15, began dinner and cocktails at the Bride's home at 11 o'clock, correct?
Yes.
Ordering drinks from your friend, splitting a burger, you were there.
I do have a picture of it, but I can remember from 2 years ago. 5 hours, if I don't remember.
Right, you can't, I mean, I could show you prior testimony, you don't.
Judge, come here, Judge.
What do you think, please?
Yeah, on cross-examination, especially in a case like this, you want to be somewhat,
When you spoke with Ms. Gouge later that evening, correct?
I was honest when I spoke with Ms. Gouge? Yeah,
Yeah. And you heard her testify this morning, correct?
I did.
And she went from champagne to wine inadvertently?
I guess so.
Okay. Or during the 5 hours. Now, you also told Ms. Gouge that indicated that you said that.
No, the assault.
All arguing in the ride from the restaurant to your residence, and just asked you at that point, correct?
That's the next thing I remember after walking the dog.
And we know there was a but yet you only have a few minutes hardwood for 40 consecutive. And your memory, you would agree, is you don't really recall how long you were at the brasserie. You don't recall how long this took place. Do you recall ever falling or in the wine? And you said you didn't recall. But
I do not recall drinking anything other than champagne that evening.
But it's possible?
No, I only recall drinking champagne that evening.
Your house, correct?
Also came out and took pictures.
But
that is not the entirety of it.
Well, did you take pictures? Why did you stay? Injuries that presented in that picture, but you would agree that there are 3 sets of pictures of the same injuries, that the bruising progressed over time, correct?
Over a couple of days, yes.
Yeah. And again, in no way to minimize, deprecate, but that's it. And the pictures are basically over and over of the same injuries as they progressed during that 3 to 5 day period, correct?
Yes, forensics took pictures of all of my injuries, and then I continued to document them.
Without a drug for 30, 40 minutes, without explanation, and why we had just had a lovely dinner for 5 hours, had cocktails and shared a burger, why this happened?
I did not say a word to him, that is correct. I laid there pretending to sleep so he would leave.
Whatever manner you got the injuries, whether it was Mr. Paschel or whether something else happened, your eyes are closed, but yet you saw him disabling your phone.
I could hear him plugging things.
How?
I did not lose consciousness again from that point.
Well, everybody had drinking, correct?
Correct.
So, lack of a better word, sobered up, correct?
Place. Did you take screenshots of your phone indicating that your phone had been signed into the defendant's computer? Before, can you tell us what that is?
To June 9th, yes.
Okay, so this would have been after you were released from the hospital?
Yes, ma'am.
The photograph that Mr. Isaacs asked you about, as far as the blood, did you provide your,
For trial.
I apologize, did you actually, the blood that was scattered throughout the house are missing?
She's got that pictures on her phone, isn't she?
Yes.
Well, but she's not showing.
Friend, okay. What time was that? Did you indicate in that text message that both you and the defendant would be?
I said we in the message.
Okay.
Port cord, et cetera, that he deleted your phone, correct?
It was backed up to the cloud.
The conversations that were stored in your iCloud.
Fiancé on TLC, he was in that show. I'd like to bring in our special guest to break this down. A guest legal, then redirect, recross. I thought she held up very well, having to testify as to the details.
I agree completely, Judge. In fact, I made that note while I was watching her testimony. You did not feel like she was grasping.
And I think, too, that she paid phone. Now, those were never introduced into evidence, and there was no further testimony about that following a sidebar. So let's talk a little bit about the reality of discovery in a case that everybody gets to see.
I acted like it was a surprise about it. After call, I've spent The vast majority of my career handling domestic violence, they're hard cases. Even when you have a cooperative victim, juries are very leery of getting involved in these kind of what they perceive as he said, she's beenly presenting the evidence, getting the evidence before the jury and setting themselves up to not only pass a directed verdict motion, but make an excellent argument.
Arrested for the February 2018 mass shooting. Separate the Parkland shooting from the battery case that's before them.
Florida versus Nicholas Cruz. Nicholas Cruz, purpose of jury selection is to find a number of people who could, regarding a school shooting, anyone sitting next to you or on the internet or from anyone at all. Now, although Nicholas Cruz is the accused, it is important to emphasize that you are not being served as a...
And you're talking about, we have this defendant in front of you, prospective jurors, but we want to know, do you know about the...
In this case, it's one of the most high-profile cases in the criminal justice system, as we said.
Had been killed and he was familiar with the family. Others knew of it or through other people, and so it also personally touched some of these prospective jurors. Now let's set. Here we go. Yes. Let's watch.
To address this coloring issue?
I can't address it.
You can or you cannot?
I can.
Okay.
Yeah, sorry.
That's okay.
If the media and the state is saying what he's writing, the state's now saying that we see him writing yesterday on the jury sheet. The state doesn't need to be concerned with what my client, as we saw yesterday, as we saw again, accommodate Mr. Cruz for 2 minutes to have some alone time to gather his thoughts for 2 minutes before we bring in the next panel.
Okay, since you told me that it's been more than, it's been, okay. Okay. Okay, thank you, sir. Thank you.
Jennifer, every time we cover,
for an appellate issue as to, proper, I don't know if a juror has said anything about it, but that's a really tough place for a judge. I've never seen that argument. I
want to delay begin, and the jury appears to be coming in, and the prosecutor appears to be keying up some body cams, so let's watch.
And prior to being in the narcotics division, just ball night into that morning.
Yes.
The knot on the head came from a wall, or did you have any knowledge as to where that had occurred?
Kristen's statement to me was that she was thrown up against and on the lower portion of his back.
And did he say how he got the scratch marks?
Yes, he said that Kristen had assaulted him.
Okay. And can you just maybe describe the marks for us?
Yes, I believe that the scratch marks.
Hey, maybe we approach the bench.
Obviously, having a sidebar about evidentiary questions or issues. And Jennifer, I'm going to have to cut you off. I apologize in advance if they go back. We don't want to miss anything that's said. But I'm assuming, my first thing out of my mouth, I tend to object. I did it when I was on the bench accidentally one time because I'm listening and I can't help it sometimes. But in my head, I wanted to say objection speculation because the answer started to be I assumed or I thought. What do you think they're talking about?
Well, it sounds like he was about to testify. Well, and they're coming back, so guess we're going to find out.
Yes, thank you.
Just by telling us how they looked, I guess, without anything further. How did the scratch marks on the body look?
They looked self-inflicted.
Oh, well.
May we have an out of jury motion?
It's obvious.
All right, Jennifer, I wish we were in the same room together because my first thing out of my mouth was mistrial. What do you think?
It's very possible at this point, but I don't know that we're quite there yet. I mean, not having tried a case in front of this judge or knowing this judge's demeanor, although having watched it, I think he may let this, I mean, it may be able to be resolved with a curative instruction to the jury that they are to disregard that statement and not take that into consideration unless the state can show that this witness would be able to make that determination based on additional, she should have asked the questions first, but if she can show that he can make that determination, maybe it comes in and here we go, we'll find out.
Basically, as an expert witness, let's see what happens.
What we want you to describe, officer, is just visually, without drawing any conclusions, any further conclusions, what did the injuries just actually look like? I'm talking about size, length, dimension, things of that nature. If you could please describe that for sure.
They were clearly from fingernails. They appeared that the scratch marks were from fingernails. They were on the chest, they were straight down. On the abdomen, they started approximately at the sternum and they went down and outward. And on the lower back, there were scratch marks that were directly horizontal on his lower back.
And just so we're clear for the record, you started at the lower sternum on each side of the sternum and moved your hands diagonally, I guess, towards the obliques on the hip.
Correct. Correct. Down and out, and they were also symmetrical.
Okay. Thank you.
And were photographs of those scratches of the defendant actually taken on scene there?
To my knowledge, yes.
And would you recognize those photographs?
I would.
Do we approach?
Yeah.
Here's your.
All right, Jennifer, let's finish that conversation while they are again up at the bench. So the problem, I think, evidence-wise, and what happened for everyone who's been watching along with us is this witness has not been presented as an expert. The correct foundation hasn't been laid at this point. So therefore, this witness cannot say his opinion or speculation or conclusion that these particular marks on the defendant that he saw were caused by being self-inflicted. What else do you have to think about that piece?
Well, I think, like I said, if she were going to try to elicit that testimony from him, obviously the witness absolutely wanted to talk about that and had some opinions that really wanted to get out. I would have anticipated that would have been addressed in trial prep, but maybe for whatever reason it wasn't. But, you know, if he were a DV investigator or something like that, perhaps you could have gotten that in that way. But I mean, he's patrolling now in narcotics, so probably not going to be able to qualify him. But the judge did not give a curative instruction, which I thought was notable. And
all right, let's go back in here.
You know.
Hard to see, remember. And right here where the pointer is up here on the screen, is that the scratches that you were referring to on the back?
Correct.
And then here, is that the same scratches on the chest and stomach?
They're hard to see, but yes.
Okay, yeah, I don't know. Right here along the rib cage, is that what you were referring to there?
Correct.
And your interaction with Ms. Wilson in Ms. Gouge's home and your interaction with the defendant in Ms. Wilson's home, was that captured on your body cam?
Correct.
Okay. All right, this time we do have a redacted video that we would like to show.
Okay. Which one will this be?
This will be the body cam.
Oh, is it all one? Okay, good. That'll be received with the previous objections noted.
Previous objection? Yes.
Okay, great.
And permission to publish.
You may. Ladies and gentlemen, certain portions of the video that you're about to see have been redacted. I'm instructing you not to place any significance at all on that fact. Those have been redacted for legal purposes. The redacted portions don't pertain to any factual issues that you'll be asked to determine in this trial. So just place no significance and don't try to speculate at all as to what was in the redacted portions. Jim?
And Judge, before I play that, may I be approached?
Yes.
All right, Jennifer, pretty standard when you have a video that's being introduced or being shown and it's redacted, the judge gives an instruction to explain. Don't pay any attention to the fact that it's redacted, and we're going to see what the rest of the video shows. But I do wonder with body cam, I'm trying to think what might have needed to be redacted in this case.
Well, and I was thinking about that too. You know, sometimes there's reference to prior events between the parties that may not have been admissible. She might have said he had assaulted her on previous occasions. And I know judges in our jurisdiction are not going to, unless without more, are not going to let that in a DV case. Or there could have been references to, I'm trying to think, usually it's a prior criminal history, but I don't think that applies in this case.
What about, and let me ask you this, I didn't mean to interrupt, but what about if the neighbor was on it? That's the other thing I thought. We know that the victim went over to the neighbors, that he responded to her at the neighbors, and I thought perhaps if there's video with the neighbor on it, that might be redacted.
It could be, but I mean, the defense has already made an objection to the hearsay of the victim with this witness, which may be what his continuing objection is to the introduction of the body cam here, and the court's overruled that. But here we go, I guess we'll see.
Just a little bit here. See, 59 seconds, roughly. And officer, just so we know what we're looking at here, is this you inside of Mrs. Gouge's kitchen?
Yes, ma'am.
And where is Miss Wilson?
She is seated, she's on the floor in front of the sink
Okay, I know it's kind of hard to see
in the shadow.
from this angle, but just to be clear, she is kind of out of the shot there underneath the sink, is that what you said?
Correct.
Okay, is she sitting on the floor?
She is.
Just a little bit. You. Well, Judge, actually. Judge, can we approach? Very briefly, sorry. I apologize.
Jennifer, they've asked to approach again, as you just heard, and I think you were right. It's the hearsay. It looked like from hands that someone was speaking, possibly a neighbor, and I think that's the reason it would be redacted.
So I agree. That looks like where it's going. She looks like she's having some technical issues too, and I feel for her because I have absolutely been there. It's hard to put up your own evidence sometimes.
And it's so frustrating, isn't it? I mean, you do all this time preparing. Let's go back.
We are lawyers up here, ladies and gentlemen, not audiovisual things. Bear with us all.
Some of it is muted, just not all of it. Okay, and this kind of shadowy figure right here that we see, is that Miss Wilson in the floor there?
It is. Miss Chapman.
Oh, Miss Chapman now.
To 9 and you currently have to get license before on my living room floor, you flip my couch and you currently have to sit and probably about 2, maybe 3 hours ago, I've been laying in bed, being asleep, he had my phone. He went through my phone, he was playing on it and deleting everything.
Okay. These guys are gonna check you out, and have them do that first, or ask some questions, okay? Did you just walk out the house, run out of the house, and do it?
Yeah,
Did you grab first?
no, I probably should.
Okay, you're fine. What's your first name?
Kristen,
So you're talking?
take all of that.
Are you familiar with their situation? Has this happened before?
But I may have to, I apologize. Apparently the actions did not work the way I wanted it to. I may have to, if I could maybe get 5 minutes just to make sure that everything wasn't taken out.
Okay.
I apologize,
Ladies and
Judge.
gentlemen, we need to work on this video a little bit before it's presented to you. I apologize for the delay, but it's something that we do have to be taken care of in an appropriate manner. So we're going to take a brief recess and allow the parties to work on that. Please don't discuss the case.
All right, they're going to take a quick recess, and the reason is because they're trying to show evidence, the body cam footage, and the prosecutor said, I just need a few minutes for some technical issues. So while they take a quick break, we will do the same. Don't go anywhere. We could bring you continuing live coverage here on Court TV, your front row seat to justice.
many of us live in a community where we think everything is okay, when many times it's really not.
911, what's the emergency? There's a white male running down the street.
Ahmaud Arbery was jogging through a South Georgia neighborhood when he was followed by 2 pickup trucks with 3 men.
We pull up beside him. Hey, stop, we want to talk to you. And he just keeps on running.
Bryant's truck is in the middle of the road. The McMichaels are behind him. He's trapped.
Should we been chasing him? I don't know.
We continue to move forward in this prosecution.
Murder in the street.
He was just jogging.
He was my baby.
That was a heartbreaking moment in the courtroom.
There's a deep culture of racism here.
This is not some hate crime. The Justice Department announced federal hate crime charges in the death of Ahmaud Arbery.
This makes you have to look at some tough issues.
Thank you for joining us here on Court TV Live. We want to turn our attention to Brunswick, Georgia, where we are less than 2 weeks away from the start of the jury selection in the case involving the death of Ahmaud Arbery. Court TV will bring you gavel-to-gavel coverage of that murder trial. The defendants in this case, Gregory and Travis McMichael, a father and a son, and their neighbor William Roddy Bryan Jr., are accused of chasing and killing 25-year-old Arbery last year as he ran in the neighborhood outside coastal Brunswick. We are learning that the prosecution and the defense teams have filed new last-minute motions just ahead of the trial. Now, in a motion filed yesterday, the state is asking to keep out information about Arbery's arrest in 2017 for shoplifting. The defense wants to keep this information in so that they can then introduce evidence that Arbery was on probation at the time of his death. In the second motion, the state is trying to exclude evidence that Arbery may have been under the influence of marijuana when he died. Court TV legal correspondent Julia Janae has been following the latest developments in the killing of Ahmaud Arbery and this trial. In a Court TV exclusive interview, she spoke to those deeply affected by the incident, the family of Ahmaud Arbery, all together.
Since February 23rd of 2020, the family of Ahmaud Arbery says they've been searching for 2 things: answers and justice. A trial for the 3 men accused of murdering Ahmaud begins in Brunswick, Georgia in just over a week with jury selection. And for the first time together, the 6 brothers and sisters of Ahmaud's father, Marcus Arbery, talk about the day they lost the 25-year-old they all called Quez.
And Ruben said no, and she said, Marcus don't know yet. And Ruben said no. So I went to Georgia Pacific to get in touch with them to tell Mark that he need to come home. But we wouldn't tell him what was going on. My sister said, no, y'all, let's wait. And then let Gary and William tell him. And it just still couldn't believe it. And they finally got a hold of Mark in Florida because he was down in Florida working. And he got out the truck and I saw the look on his face, and he was just like he was looking around like he was saying, well, everybody him. So he couldn't figure out what was going on. And then my 2 brothers walked him down the street. And when I heard my brother holler, I already knew they hadn't told him what happened. And he left there, him and my sister and Gary, and went to Satilla.
What did you see in Satilla Shores when you went there that day?
I seen all my kid blood on the ground. My brother showed me where the spot where he was murdered at. Part of blood was on the ground. They tried to wash up, but you know how blood is, they couldn't even wash it up. Ran him down and murdered him. Ran him down. And Lord, when that video came out, it like to kill my 2 children. It like to kill my family too. Because we never seen nothing like that in our life before.
Ahmaud's family says they faced one of the accused defendants in that Satilla Shores neighborhood not too long after Ahmaud's death and long before any arrests were made. Coming up on Friday, we'll have the full details from their full interview and what they hope the world pays attention to as this case unfolds in a courtroom. Julia Janae, Court TV.
And you can watch Julia Janae's full exclusive interview with the Arbery family speaks this Friday at 7 p.m., 6 p.m. Central, right here on Court TV Live. Up next, still to come, we will take you back to Tennessee where the former 90 Day Fiancé cast member is on trial. Welcome back to Court TV Live. I'm Ashley Wilcott. So thankful you are here with us as we continue to break it down. We've got a lot to cover, bringing you a lot live. We want to start first with Tennessee versus Geoffrey Paschel, the former reality TV star who is accused of a brutal attack on his former fiancé. Paschel, who appeared on the reality show 90 Day Fiancé before the 90 days, is accused of assaulting his then fiancé in June of 2019. The victim claims that Paschel brutally attacked her while he continues to maintain his innocence. Paschel is charged with kidnapping, domestic assault, interference with an emergency call, and vandalism. Jury selection began and ended this morning, and before lunch, the prosecution and defense delivered their opening statements. Also, the first witness, the victim's neighbor, took the stand to testify. Let's listen to the prosecution and defense opening statements together.
You can hear from her how he grabbed her by the back of her head and slammed her head into the hardwood floor repeatedly. You're going to hear how he grabbed her by the back of her neck, drug her around the house, drug her up the stairs. You're going to see where she had blood on her face and was trying to reach for a light switch. You're going to see blood smears on the light switches. You're going to see blood splattered on the wall, dripped on the floor. You're going to hear how she tried to get away and she couldn't. You're going to see scrapes on her knees, scrapes on her elbows, bruises everywhere. Bruises on the back of her neck where he grabbed her when he was slamming her head on the floor. You're going to hear how this happened for what seemed like forever. Ms. Wilson's going to tell you that she blacked out multiple times, lost consciousness because of the injury to her head. And then she's going to tell you that the defendant told her, go wash your face. After he took her phone and took her car keys, go wash your face. So she did. She was terrified. She just wanted it to stop. She went, she washed her face, she washed all the blood off of it best she could. He said, go lay down. So she did.
You're going to hear that based on the factors, alcohol, whatever, that Ms. Wilson became upset. You're going to hear that there was an argument. She injured herself leaving the house. She injured herself during the argument and the interaction with Mr. Paschel. No more, no less. You're going to see pictures. And when you see those pictures, I'm going to ask you, when I get back up here after the proof of this trial, to call upon your life experiences and your common sense. And the proof is going to show that Ms. Wilson had a pump knot, significant, some inner bleeding in her mouth, and you're going to hear that happened because of injuries she incurred leaving the house down the road that Mr. Paschel is going to take us on during the course of this trial. But the state is going to tell you that Mr. Paschel brutalized her for no reason whatsoever, and it went on forever.
Still with me, former U.S. Attorney Jennifer Wells, and also joining us now live, trial attorney Greg Francis. Here's what I'd like to do. I'd like us to talk about the prosecution's opening, the defense's opening, in terms of trial skills and whether or not you felt that it was a compelling argument. So I'd like to start with you, if I could, Greg. And one of the things is talking about the state's opening. The prosecutor used a lot of adjectives to really describe and paint a picture for the jury. The blood spatter, the scrapes, bruises, that she was slammed on the floor, that the victim blacked out. How compelling did you find this portion of the opening statement by the prosecution?
I found it to be very compelling. You know, this is their first opportunity to speak to the jury directly and lay out, you know, what the facts of the case are and what they proved. What I heard was a lot of description of the injuries that occurred and the severity of the injuries that occurred. And I think those are the things that kind of move a jury and will allow a jury to really focus on the pictures and the physical evidence in the case.
A picture is worth 1,000 words. We're looking at the picture of the knot on her head, and that is no small knot. It takes a lot of force. Jennifer, I know that you've been involved in domestic violence cases in your career as an attorney. The amount of force it takes to have that type of knot on your forehead and some of these other injuries, I think is pretty significant.
Oh, I agree. When I saw that picture for the first time, I thought, just from experience, not only as an attorney, but also as someone who parents children who may be a little clumsy, it is going to take more than a fall probably to. But again, I don't know how they're going to get that testimony in. But yes, it would take a lot of force to get that, and the bruising and the inside of her lip as well. That is a really indicative of some sort of assault to me, based on my experience handling these types of cases.
Right. No, I don't disagree. Let's listen to some of what the victim herself had to say when she took the stand earlier today and testified.
You said you all had dinner and drinks. What were you drinking?
Champagne.
Do you recall how much you had to drink?
I recall that I had 3 glasses of champagne.
Who was driving that night?
I drove.
Okay. And did Mr. Paschel have anything to drink?
Yes.
And what do you recall what he was drinking?
Double whiskey and Cokes.
Okay. And so when you get back in the house, you said, tell us exactly what you remember as soon as you get back into the house after walking the dog.
After coming up my driveway, the next thing I remember, I was on the floor in front of my staircase that leads to the upstairs, and he had me by the back of my head and was hitting my face into the floor, and I was screaming for him to stop.
Okay. Is that all that happened, or?
No. From there, he dragged me up the stairs. It's not quite a split level, but there's like 4 stairs that lead up to the bedroom, and it's hardwood floors, and he was dragging me by my head and by my hair. He had me kind of by the back of the neck, and we went up the stairs towards the bedrooms, and I blacked out again. I lost consciousness.
All right, Greg, in your experience as a trial attorney, how would you assess the effectiveness of her testimony?
Extremely effective. She basically described what the injuries that occurred that are viewed in the pictures in this case. She has been honest about the fact that there was alcohol involved that evening, which I think is a good choice by the prosecutor to bring that out on their own rather than have that come up in the dense cross-examination of the victim here and then some kind of way try to discredit her testimony. So, I mean, her testimony about exactly what happened, how it happened, seems to be very consistent with the pictures that have been shown in this case, and inconsistent with, I think, the defense in this case that she did it to herself.
Right. And Greg, I absolutely agree with you. We don't want to hide facts or bury facts. You want to bury them in there, but also get it out through your own witness. The champagne, to your point, she was very matter of fact. I had 3 glasses of champagne. So let's pivot, Jennifer, if we could, to what Greg just alluded to, and that is the defense opening statement and the defense argument that really it was the victim, that she was upset, that she injured herself, that she was leaving the house. How did you feel about that argument for the defense?
I'm not sure, based on what we've heard so far, that that's going to be supported by the evidence the state has put in at this point. Now, perhaps, then reading in perhaps to the opening statement, that this defendant may testify, and perhaps he is going to allude to some sort of triggering event that would have caused her to do this to herself. But I'm not sure at this point that we have that evidence in front of us.
And look at this picture that they're showing right now that we at Court TV are showing, and that is, it looks like a bruise on the right side of his face, right under his eye, on that bone, on his cheekbone. Now, we didn't hear any testimony about that, but just interesting to note. Now, I am watching, and I believe that the court is back on the bench. Yes, let's go back into court live.
38 mark. That has been properly admitted as evidence, and that is something that you will be able to consider as part of the proof in this case. All of these exhibits, by the way, when you deliberate on the case, they will go back to you, the jury room, and you'll be able to review them as you wish. And I think here in a second, the general is about to play a portion of the video from later on that body cam. General, if you'd like to proceed.
Yes, Judge, we're going to start at 5 minutes and 24 seconds within this video. If a lot is here.
All the way. Hey, stop. You guys, you know what you had your hand. Nothing. Nothing else. No. You don't have permission to come in here? Oh, yes, we do. Oh, yes, we do. Look at all these scratches on them. What's going on? How do you think? Have a seat. Have a seat. Right there. You want to know the exact truth? Have a seat. Have a seat. I'm not going to tell you again. Right there. It's right there. It's fine. Right there. Whatever. She's a little girl. All right. It's okay. Okay. Tell me.
And it's kind of hard to see in the video, but were all the lights off in the home when you all went in?
Yes.
Okay.
She's mad at the little girl. Okay. She acted absolutely, crazy. I mean, scratched me, ran against the wall, hit herself, slapped herself, said she's gonna call you guys, and I said, I'm gonna leave. I mean, that's the extent of it. I mean, she ran. Where, I said, yeah, I said, I said, where, that's it, right now, keep right here. Where did she supposedly run the wall? That's supposedly, she really did. Right here. And she came out of the bedroom, said she was hugely angry, screaming. She's done this before, this is not the first time. First time you heard of her? Yeah. And she ran to the wall, probably in this area right here. And I mean, she slapped herself, she scratched herself. I mean, she was acting absolutely absurd. I mean, just crazy. And I said, just stop. And I've done this before. I didn't call them. I don't want to call you guys. I'm going to see if I can.
Judge, I'm going to stop it for the record at 7:29 on that video.
Okay. Good.
All right, officer, and the person that we just saw on the body cam there, do you see that person in the room, the gentleman?
We'll stipulate it's Mr. Paschel. There you go.
And I'll pass it to Ms. Judge. Thank you.
No questions.
All right, very well.
Officer, you can step down, sir.
General, please, with us.
Guard of State Rest.
Okay, ladies and gentlemen, the state has rested its case in chief. That does mean that there is some business that we have to take up outside your presence. I know we just took a break, but it is also, it's 4:15. There are several legal issues that the parties need to discuss. The defense, of course, has an opportunity, if they choose to do so, to put on proof in this case, although they're not obligated to. And I also need to have a discussion with the lawyers regarding the jury instructions that you'll receive in this case, which you'll find out tomorrow can be a little lengthy, and that is something that we did need to discuss in detail. So instead of keeping you here for the rest of the day, we're going to go ahead and let you go, and we'll come back and pick up the case tomorrow. We have made good progress today, so it does look like you will get the case for deliberation beginning tomorrow. I do have a regular docket that I have to attend to at 9 o'clock. I'm going to instruct everyone to get in here so we can get through that quickly, relatively quickly, and I'm going to ask the parties to come back so we can start the trial back at 10 o'clock. So if you guys could show up here 9:45, 9:50, and be ready to go at 10 o'clock, we'll resume the trial at that point with the defense group if there is going to be any. Now, before you leave for the evening, of course, we've had these discussions before, but it's very important, so I need to tell you before you leave for the day. When you get home, your friends, family, loved ones are going to be very curious about where you've been and what you've been doing. They're going to ask you what kind of case this is. They're going to want to know all of the details. And as I said earlier, you can't say anything about the case. Please just let them know that these are my rules and you're simply following my instructions. Do not discuss this case with anybody. Do not try to find out any information about the case. As I said earlier, the case has received some media attention, so it's very important that you don't look at any of that. Don't try to find any of it on the internet. I don't know that it will be on the local television, but try to avoid local news tonight, okay? If you are driving in the car and something starts to come on the radio, just turn it off. I don't know if it's going to happen, but just to err on the side of caution, at least for this one night until we get this case finished, okay? Thank you all so much for your work on the case. You have not heard everything that you need to hear before you start making your decisions, so please don't start deliberating even in your own mind. Don't form any opinions about the case. Just try to put the case out of your mind tonight and get a little rest, come back fresh and ready to go tomorrow. Thank you all so much. You're please really awesome.
All right, the jury's been excused for the day. What just happened? 3 witnesses were called. The state then rested. They're going to take up some items outside the presence of the jury. The jury's been told to come back at 10 a.m. in the morning because we do have a judge who has another matter to handle at 9 o'clock. So he said come back at 10, and then we'll know more about whether or not the defense is going to put up a case. We don't know yet. Is this defendant going to testify? Let's squeeze in a quick break while we have that opportunity and then rejoin us here on Court TV, your front row seat to justice.